had taken place while providing for
Dealing with the postal subject, the court number 2 has released my part-heard matter, my lord. So, my lord,
It will be put up before the Chief Justice on administrative side.
please.
There is no need to give any memo in that regard.
This is the part-heard matter, my lord. I am coming from Delhi. I have completed.
So please approach the Registrar Judicial. Yes.
Kindly, contempt petition. Similar matters are coming up tomorrow, my lord, for compliance of the Lordship's order. It is itself tomorrow, my lord. This petition also will be connected along with that petition. There's been office objections have been complied.
So what do you want?
Will be posted tomorrow, my lord.
It will come in. It will be, what is the
Similar matters are coming up, my lord. I also pray this honorable court to post this.
similar means what?
Similar matter, my lord.
Arising out of same order?
Yes.
Same order. Oh.
Please.
Yes.
And my lord, the writ appeals batch of 22 petitions, my lord, against the order of the learned single judge. In which matter, my lord, notice has been ordered. Our interim prayer has to be considered, my lord.
If it is not considered initial till, let the other side appear, then we'll consider.
Matter is against the case of you, my lord.
Notice is already issued.
Please,
Then no, let it come on the returnable date.
Since is this, my lord, the several petitions.
Then file IA. File IA.
My lords, a notification by the Karnataka Urban Water Supply and Drainage Board appointing drivers has been quashed by orders of a learned single judge, my lord. There's an urgency in the matter, it may please be had. The office of objections have been complied, my lords.
Within 1 week. Yes.
Lordship, kindly matter for advancement of the writ appeal.
No advancement once the judicial order date is given.
No, it's not, my lord. What happened on that matter could not be heard on that day for want of time. That's why the cases are ordered.
There will be no advancement of any matter unless you file IA for advancement. By oral submission and oral order, no change in the judicial order. Yes.
Commercial appeal, my lord. The respondent filed a execution petition.
Commercial appeal, you have to go before the appropriate branch.
Sir, I have filed an IA for recall of the order. I wanted to for posting for tomorrow.
What is the subject matter?
Sir,
What is the subject matter?
recall of the order dated 17/11/23 in PIL.
With your lordship's most gracious permission, my lord, Advocate Danubara, my lord, I mentioned the other day, then your lordship has been gracious enough to ask me to mention today. The urgency is, my lord, I was thrown out of my form. There was an order of the learned single judge to restore possession. And that order came to be vacated because a couple of occasions I couldn't come to Bangalore, or there was some glitch in the internet problem, so I couldn't appear. So for a restoration of possession, that order was vacated, and the appeal is in challenge of the interim order, which came to be vacated for default. Am I audible, my lord? Am I audible? Am I audible, my lord?
Audible, yes, but still.
What you are mentioning not able to properly.
No, my lord,
Audible.
an appeal has filed in challenge of an order of a single judge vacating the direction to restore possession. And such an order came to be passed because of non-appearance. And the reason for non-appearance was, my lord, I was appearing online, and due to technical reasons, technical glitches, I couldn't appear. So that was the reason for the non-appearance. I was trying to appear online. And thereafter, my lord, I came many times physically also, but the matter was never listed. I mentioned before Justice Varale, his lordship was pleased to give a particular date. However, it was not listed. So, my lord, I only ask him for a urgent listing. Any near date of your lordship's most gracious choice. Am I audible, my lord?
given, but after that it was not posted at all, my lord.
Not posted.
No.
My lord,
You
writ
check
appeal.
up if it is not posted on the given date, post. If date is yet to reach, then
Am I
don't.
audible, my lord? Yeah.
It is
am-
anterior, then yes. Wait. It anterior date and not posted. It may be posted this week. If it is to posted
For
at a
the
future point
preservation-
of time, then no.
It is
change.
for the preservation of the pristine Karwar beach. my lord.
Only thing that it is already, date is already gone, then we'll list. If date is yet to arrive, then we'll not pass any order. It will be listed on the next date.
Obliged, my lord.
My lord, writ appeal, my lord. The appellant date of birth is wrongly entered in the respondent company and he has been superannuated, my lord. Another 10 months were being left.
So
my-
you are wrongly made party.
Yes, my lord.
Come when it is listed.
So he has been superannuated, my lord.
No, for that, on that ground, it can be listed.
Well,
You come and say that I want to be deleted when it is posted. For that,
Okay,
no
office
urgent
objection has also been complained.
listing. For that, there is no urgent listing. Yes, madam.
My lords, writ appeal, my lords, already heard the matter. While senior counsel has argued the matter, respondent took the time. After, it was supposed to be posted after a week, but it was not posting.
Not posted within week. It will be posted within 1 week.
Date may be given, my lord.
Take date. from the
Oh,
court office.
I'm so sorry to bother your lordship, my lord. There was some connectivity issue. I couldn't hear your lordship. I was asking for a listing.
Your voice is not.
Yes, my lord, I couldn't hear your lordship.
Not audible.
Now I can. Yes.
We have spent 7 minutes in conversation as to the posting. We do not do it. Yes.
Notice.
They are not completed. Also, I'm kindly see, 1 year back, we had given representation.
Notice has to go.
Actually,
Can we do without notice? There is a protocol under the
yes,
rules.
my lord. Laches, you are given only 2 weeks time to comply the order. Otherwise, but they are not complied.
Therefore, notice has to go.
After vacation.
You accept notice for?
R5, learned government advocate Mahendra accepts notice for respondent 5.
So number 2, Mr. Venkatesh R. I appear for the complaint in this matter.
Which provision provides for condonation of delay?
We have filed the application under section 5 of the Limitation Act.
Show that when special, see, Contempt of Courts Act 1971 is a special act.
Yes, please.
It prescribes limitation.
I'll
Does
make-
it say the provisions of section 5 of the Limitation Act would be applicable? That is the question.
I'll file a fresh application. please.
Huh?
I'll file a fresh application.
What fresh application?
Uh,
How
correcting the
application is
provision.
maintainable? Please read section 20, 21, same thing. You have section 20. Show that.
No court shall initiate any proceedings of contempt either on its own motion or otherwise after the expiry of period of 1 year from the date on which the contempt is alleged to have been committed.
Now, the only way is the other benches. Same it has been held. See, once the time has expired, there is some juridical view
Please.
to the effect that no limitation period, once limitation period expires, there is no provision for condonation of delay. The
Please.
best way in such a matter is suggested by Honorable Justice G. Ramesh bench.
Please.
You have to make an application to the judge seeking extension of the period.
Please.
Then you have to come.
Please,
You can.
I'll do it.
As such.
So
So what shall we do? What shall-
202 days delay.
Instead, you can withdraw this petition. Instead of we making order, you can withdraw this petition. We are just thinking
Please.
aloud. We are not even suggesting.
Please.
So think about that, whether you can go before the single judge.
It's only a delay of 202 days, not 1 year.
There is no question of delay here. Once 1 year is over,
Order.
I got.
Order.
the cause of action extinguished.
I may be permitted to- with liberty to file a fresh petition.
That's what.
The learned advocate, Mr. Venkatesh R, seeks permission to withdraw the present contempt petition. He requests that the liberty may be reserved to initiate the appropriate proceedings in the respect of the subject matter.
And the certified copy of the annexure may
It
be
is
ordered
reserved
to be
subject
rejected.
to the laws of providing and making it permissible for the applicant to initiate such proceedings for which this court does not express any opinion.
The certified copies may be
All
ordered to be
certificate
rejected.
copies you will get.
Please.
That is procedural. You get it.
Still number 3, the Ramakrishna Hegde. Yes.
Lord,
Suit is pending,
suit is pending, Lord.
then go there. Go there.
No, my Lord.
The view.
Oh.
Already we have taken the view.
Submission. Lord, the civil court granted the interim order, my Lord, by following the application under order 13 and rule 1 and 2.
Correct.
It was challenged by the respondent in the senior division court in MA, my Lord. MA was allowed. It was challenged by me in the High Court. In the High Court, my Lord. In the High Court. In the High Court.
Yes, yes,
This is my submission.
yes.
In the High Court, my Lord, on 28 December, the respondent undertook not to obstruct the use of the road, my Lord. And on the same undertaking, Lord, on 2nd January, my Lord, the single learned judge, my Lord, passed the status quo order. On the same, my Lord, undertaking, my Lord, the writ petition was disposed of, directing the both parties to maintain status quo till disposal of the suit. My Lord, suit is pending. Instead of obeying the order of this on the High Court, the respondent dumped 2 lorries of mud in the road, subsequent to order of status quo, my Lord. I have sent a representation. The respondent is saying that, my Lord, they have closed the road prior to the order in MA. But in the High Court, my Lord,
Once the subject matter is tried by the court in the suit proceedings, it will be the same court which will be able to comprehensively deal with your grievance, including this breach of status quo. So we are not inclined to entertain.
Similar matters that we was
We have disposed of.
identical.
then I may be permitted to move the necessary application before the.
Right.
Yes,
Please,
full stop.
same.
It is the following.
There is a
direction.
disobedience.
It is the following directions in order dated 11/1/24. In writ petition number 29156023 passed by learned single judge, which are brought under contempt jurisdiction on page 17, operative order quoted, full stop. From the above order, it is evident that the proceedings of the suit is pending before the court below. The direction is to maintain status quo till the disposal of the suit. The complaint of breach about the status quo could well be urged before the court where the suit is pending. Full stop. Paragraph. In the facts and circumstances, and since the suit is pending, where the complainant would raise the grievance about the breach, these contempt proceedings are not, these contempt proceedings are not entertained, reserving liberty for the applicant to approach the
Necessary application before.
court below by filing necessary application to work out in accordance with law his rights and remedies.
Much of.
Disposed of accordingly.
Still number 4, Mr. Mubarak.
Lords, I appear for compliance, my lord. The accused has not complied the order passed by this honorable single bench, my lord. I have given the representation after receiving the certified copy of this order, my lord. In fact, the directions were given to the accused number 1 and 2 to fix the proper fixation of 1/1/1997 pay revision, my lord, to the petitioner, to the complainant, my lord, and also
You repeat? Not all learned advocate Miss
Mubarak Beg.
Begum as notice written out
Please.
in the first week after reopening.
3rd June. Still
Yes,
number 5. Padri Vishal.
So honorable court directed my lords to consider the occupancy rights proceeding now with the period
Or
period of
learned
6
advocate
months.
Mr. Srinivas, S. Srinivas.
I accept for R1.
Notice returnable first week of reopening, any date. Learned government advocate accept notice on behalf of R2. R1.
3rd June. Seal number 6. P. Vidulata.
Madam is not in station, my lord, my colleague, my lord. She has requested me to represent. My lord.
Here also.
R5.
Okay.
R5.
Same, also and so notice.
Please.
Second week of reopening, learned government advocate. Accept the notice. On behalf of R5.
R5.
3rd June. Seal number 7.
Complainants counsel. Directions at page 30, my lord. Order dated 26/7/23. Division bench, my lord, modified the learned single judge's order and directed KIDB to initiate proceedings in clause A and B, and that the inquiry should be completed in 4 months. That's not happened. I say so specifically at paragraph 14 of the
Or learned senior advocate Mr.
Nandakumar, C.K. Nandakumar.
For the complainant, notice returnable on
Lordship.
first week of reopening.
Seal number 8. To Keshavamurthy CN.
Permitted to appear for the complainant.
Withdrawing.
Interim order.
Learned advocate Mr.
I am-
Keshavamurthy, 6.
I am representing-
Realizing that the order brought under contempt is a interim order and that the applicant could approach the learned single judge to raise the similar grievance and work out his rights and remedies in accordance with law. Disposed of accordingly as withdrawn. Such liberty is reserved. However, without expressing any opinion on that score. Yes.
Seal number 9. Mr. Keshav Bhatt.
Notice.
Very
Notice. Will be appeal?
Yes, your lord. GF or AGF
Second week of reopening.
for R2.
Learned government. Yes, for R2.
Only one response.
Seal number 10. Green bench matters. Mr. Prakash B. Petitioner.
Grievance of the petitioner, my lord.
Are you having the copy of this? You have got the copy of this petition, this writ petition.
Are you served with a copy? Yes, yes.
So his application had lapsed.
No, Lord. We'll consider this application. Prayer too may be.
That is the prayer, but was it lapsed?
No.
He wants consideration in light of 23 amendment.
That's true, Lord. But he has filed a writ petition.
So then we
And
dispose.
that rejection was set aside in this matter.
We'll dispose it of.
Please, my lord,
That is the
please, my
only-
lord.
Consider.
Heard learned advocate Mr. Prakash BS for the petitioner and learned government advocate Mr. Mahendra, who is served with, who appears upon service of copy of the petition in advance. The only prayer which is made in this writ petition filed under Article 226 of the Constitution is to direct Dispute number 3 as the senior geologist, Department of Mines and Geology, Hassan, to consider the application of petitioner dated 16/7/15 within a time frame, within a time bound, 16/7/15 time bound, and time bound for grant of lease. The application paragraph is produced. Copy of the application is produced at Annexure A. The case of the petitioner is that by side application dated 16/7/15, the third respondent was requested to grant co-release for quarrying building stone, which is classified as non-specified minor mineral as per the Karnataka Minor Mineral Concession Rules, 1994. Full stop. The quarry lease is applied in respect of survey number 26 at Basava Nayakan Halli village, Olenara Sipura Taluk, in the area measuring 4 acres for a period of 10 years. the application is made and the said application is under Rule 22(1) of the Karnataka of the aforesaid rules. It is stated by the petitioner that no objection certificate is required under the rules have been received in time, and that the petitioner has complied with other requirements of the rules. Full stop. Having regard to the prayer made, it is directed that the competent authority of the respondents shall consider the application of the petitioner for grant of co-release and render a decision, taking into account the operative facts in accordance with the, preferably within a period of 8 weeks.
12 weeks.
12 weeks. It is clarified that while all the contentions of both the sides are kept open, and further that this court has not expressed any opinion on the merits of the request of the petition.
Only grievances, second time they have written for no objection, my lord. Though it was received earlier.
Whenever the case is remanded to
Please,
authority,
Bella.
never express it.
Please, my lord, please, my lord. The other issue is
Petition is
also
disposed
same.
of accordingly.
Same order.
No, the level in this matter we have.
Expired. Rejected. They have communicated the order now.
No, they have given it just now, my lord.
They have communicated. Now see, take that order, recourse to that. This petition does not survive.
Now, what happens here, my lord? They say the area applied is, extent is less than the minimum prescribed is what they have
You
said.
challenged the order.
Please, my lord. No, that we have not challenged.
Therefore,
I may
there
be
is no
permitted
cause
to
of
challenge this, my lord.
This is disposed of.
Please, my lord, please, my lord.
The only prayer in this petition was to require the third respondent to consider the application dated 16/7/2015. Consider of the petitioner for grant of co-release in survey number 26. Same survey
Same
number,
village, same survey number, everything is same, my lord. It is contiguous also.
Same. In the area at measuring 1 acre and 30 guntas.
30 guntas.
Full stop. 1.3 acres. Full stop. The paragraph, when the petition came up for consideration, learned government advocate Mr. Mahendra, appearing upon service of the copy of the petition in advance, made a statement that the competent authority is already rejected the application of petition by order dated by endorsement. Endorsement dated 12th March 24.
24 months.
Learned advocate Mr. Prakash B.S. could not dispute the factum of the passing of the aforesaid endorsement. He, however, submitted that liberty may be reserved to challenge the said endorsement.
Please.
Such liberty is reserved in accordance with law, for which this court does not express any opinion on merits. Full stop. This petition does not survive for its prayer made in accordance with this court.
Please, please.
Number 12, Anirudhan.
The subject matter of this petition, my lords, is drawing the attention of the Honorable Supreme Court. It's covered, my lords, at Annexure H, my lords. Can I request my lords to take page number 192, my lords, 194. Please, my lords. I've marked it as an annexure, my lords.
This is a thing.
Page number 2, please.
Pending before Supreme Court.
Yes.
Please, my lords.
Then why we should entertain?
No, my lords, can I request my lords?
I think we have already issued interim order also.
Please, my
Interim
lords.
order is there.
Annexure H at 194, if my lords would take, my lords. I've
Next
produced
page,
that.
Next page. In view of the fact that the apex court has extended interim order passed by the High Court, we ask in interim order.
Our learned advocate Mr. Anirudhan, please, for the petitioner. What is the prayer made in this petition? Thailand Article 226 of the Constitution is to declare that the Karnataka Minor Mineral Concession into bracket amendment, bracket or rules 2016, dated 12/8/16, are unconstitutional. Also, the virus of the rules thus are under challenge. In course of the consideration of the petition, it was pointed out by learned advocate for the petitioner as well as learned advocate, learned government advocate, Mr. Mahendra, that the identical issue is pending before the Honorable Supreme Court for consideration. It was also jointly stated. It was also stated by both the learned counsels that in similar petitions, it was one of which was the writ petition number 6886 of 22. This court has also granted interim leave in view that the apex court has extended the interim order passed by the High Court in such petitions. Also, in that view, in that light, by of interim measure, it is provided that the petitioner shall be permitted to carry out forwarding operations, and the authorities shall issue permit on payment of royalty as per the existing notification, provided that the petitioner possesses forwarding plan and environment clearance certificate.
Which the connected matters, this honorable court has deferred those petitions with liberty to the petitioners to mention the matter after the SLP is disposed of. It's the similar.
Do it.
This may be tagged along with blood.
So that they can come along with them.
He'll come along with.
To be listed with writ petition number 6886 of 22 and other related.
Great.
So in the same language.
Same.
This is number 13, Mr. P. Mahesh.
The similar writ petition was allowed by this honorable court.
But annexure D is translated or not? Translated. So
Has been translated.
Yes.
Page number 49. Seeking for writ of
Laches. Similar writ petitions have been allowed.
Disposed of.
by the other
It is
association.
neither private interest nor public interest.
Yes. By the other association, by the other districts.
How you are concerned with this cause?
My lordship, here what happening, my lordship? The government is permitting contractors, my lordship, to pay the royalty in their bill. My lordship, they are not getting MDP from the quarry owners and crusher holders, my lordship. They are getting the minor mineral, my lordship.
Same land. Following are the prayers made in this petition. Then page 14 over 1, 2, 3. The representation dated 28, 10, 23 and 1, 124 referred to in the prayer clause as above are produced at annexure D and E. Learned advocate for the petitioner. P. Mahesh.
P. Mahesh.
Pointed out that that the similar petition, that the writ petition number 437/24 involving the similar subject matter in which the similar kind of prayer was made, came to be disposed of by the coordinate bench by order dated 27th February 2024. Full stop. Copy of the order was produced before this court. This petition's paragraph is disposed of in the same terms by permitting the petitioner to submit additional set of representations to the competent authority respondents within 2 weeks. The respondent shall consider such representations in accordance with law within 12 weeks from the date of receipt. full stop. Learned Government Advocate Mr. Mahendra appears and submits that the representations will be looked into as per law and shall be decided in accordance with the petition is disposed. Therefore, it comes.
Number 14, Mr. Vignesh, where are you?
For the petitioner's counsel. I have a stone crusher license. That was cancelled and set aside by this honorable court with liberty to take action, my lords, after hearing us. Now, by virtue of that,
what portal do you want?
Lords, the problem is there is something known as ILMS, Integrated Lease Management System, where permits are generated through it. When it was cancelled, it was suspended. Now I'm asking for, since that order cancellation has been set aside by the division bench of this honorable court, I'm asking for revival of that so that I can carry on my operations.
Some breach of condition on your part.
Yes.
It is within.
No, it was cancelled on distance issue, my lords. That was set aside.
Portal must have been cancelled because of some breach on your.
I have that order where we have produced that.
That is
not on breach, my lords. They had conducted.
Page 37.
My lords, the order which was challenged at page 19, which was set aside by this honorable court, if your lordship comes to page 31. 31 is the order of the division bench of this honorable
And in
court.
pursuance of this order, today, my lord, the joint inspection they are conducting.
Correct, but till then I have a right to, my lords, carry on my operations.
it is
It's a
within.
crushing operations. Otherwise, there's no point in, my lords, me succeeding in an order.
You want to take instruction, then I will issue notice.
Or because I have a right for.
Consider the request.
Lords, but then.
They are
my lords,
considering their.
There is limited.
limited, but now, my lords, from 1 month I have been struggling to get a.
That's all right. Very prayer is to consider your request, nothing beyond.
But then, my lords, there is, the issue is, lords, if it is a, may I just make this? Consideration is yes, but my lords, when I have a right to carry on the operations, they can't take more than a month now without, I may. Operations are stuck. Lords, no, it is like this. I had a ILMS system. Under the rules, my lords, I had a system. They have suspended that. Now that order of cancellation has been set aside automatically. I am entitled.
Anyway, today they are undertaking the.
Raising grievance, write down. Right. Raising grievance on behalf of the petitioner, learned senior advocate Mr. Panindra, assisted by learned advocate Mr. Vigneshwar. Raised a grievance that the order is made on 15/12/23 by the competent authority suspending the C form in the name of the petitioner, Messrs. Sri Venkateswara Hill Crusher. And the portal has been blocked. It was submitted that due to blocking of the portal, the petitioner is not able to take out the permits and to carry out the crusher operations, which have been stopped on account of non-responsive portal.
Order of cancellation was set aside by this court.
While considering the grievance of the petitioner, when the prayer made in the petition is seen, it is only to require the number 1 to 3 to consider the request letters dated 9/2/24, 2/3/24 and 4/3/24 addressed by the petitioner to the authorities, which are produced at Annexure D, E and F respectively. Full stop. In the said letters, the petitioner has made requests to the authorities to release the ILMS portal in favor of the petitioner. Paragraph. Learned advocate, government advocate, Mr. Mahindra, who appears upon service of copy of the petition in advance, stated that the authorities are already in the process of considering the request letters forwarded by the petitioner and have been looking into the grievance of the petitioner about the blocking of the portal. He stated that appropriate decision in accordance.
Today,
with-
joint inspection is
He further
contemplated.
said that
Today, joint
joint
inspection
inspection is
for
also
declaring.
being undertaken at the site of the petition.
Yes.
Full stop. since the material developments have taken place, wherein the respondents' authorities have been active in considering the request of the petitioner, and the joint checking is also being done, in that view and further in view of the limited prayer made, the only direction which court could issue is to require the respondent authorities to consider the request of the petitioner regarding the portal in accordance with law. So the decision in that regard may be taken within 4 weeks from today.
It's 2 weeks, more than 1 month. My entire business is stopped.
Minimum
It's
8
only a
weeks, my lord,
port-
because in the earlier petition also 2 months time is granted.
3 weeks.
Before that only they rushed to the court and filed this
No,
petition.
that was, my lord's cancellation order was set aside. I had a right to carry.
4 weeks is natural.
4 weeks.
4 weeks.
Lords, 1 month already spent. My working is stopped, though I have succeeded.
Things are on way, on the road. And
But
joint
we have-
inspection is free.
Because our staff is more than 100 people, my lords, I have no work to do. At least 3 weeks, your lord, 4 weeks,
He is seeking 8 weeks.
lords.
It
They will
is
seek,
clear
my lord, but the
now,
right is of
even
the
Lord
person who
Code of
has a right.
Conduct,
to
The elections are there
When your inspection will be over today itself,
today. my lord.
Will it be over today?
It will be over today.
then
We'll consider, my lord, before that only.
do
Four-
it as early as
Let
possible.
it be 4 months, 4 weeks, my lord. I accept notice for response.
We are disposing of it. So in the beginning, notice and learner.
Appeal matters, number 15, CH-1 Renuka.
This is an appeal by the corporation, my lord. Respondent, my lord, was a conductor. The charge against him, my lord, that he had failed to issue tickets to 20 passengers, my lord, and had not collected fare. My lord, the learned single judge is also the labor court, my lord, holds that. As regard to the charge is concerned, my lord, that is held to be proved, my lord. It only says that, my lord, that
26 passengers, 18. Then
well,
18 were not given.
the pass holders, my lord, were, there were 54 pass holders, my lord. The only issue, my lord, was that the issue was that, my lord, he was required to issue tickets, my lord, before the stage point. My lord, I have not, my lord, I have not charged him, my lord, in between the stages.
Notice written. Second week of after vacation. For learned everybody, so and so.
10th of June. Number 16, Govind Raj K.
You are for? So agreed by non-granting of full back wages. You are agreed because full back wages are not granted. Where is the other cross appeal? Today and what?
Not posted. It has to be called upon, issue notice and call upon.
Notice.
In that notice is ordered.
When it is kept? Are you aware?
Appeal number.
So we say notice to be, notice and this. Notice returnable heard so and so, notice returnable on second week of reopening, full stop. The cross appeal arising out of same judgment and order of learned single judge filed by the management shall be, filed by the employer shall be listed along with, have you got the number? 49023 filed by the employer shall be listed along with the present rate of it.
Number 17.
Not issue tickets, my lord, to the 3/4 of the passengers, my lord. Out of 26, 18 were not issued with tickets, my lord. And 97 passed misconduct. Para 8 of the order of the learned
So
single
you are
judge.
for whom?
Page 17.
Corporate. So that is, it is in your favor.
Well, in page 17, para 8, my lord.
So original order was of dismissal and substituted by the
Yes, sir.
third learned advocate, so and so and so notice returnable, second week of reopening.
11-6. Still number 18.
For
Vasudev.
the appellant, my lords. In
Where
this
you were
case,
for 4 decades?
advocate is not there, but
4 decades. 4 decades you are sleeping.
yes,
The order of the tribunal is 42 years old.
it is not because I have not been heard. Unilaterally, without hearing me, I have been defrauded, please, my lord, by the other side, without notice, this order came to be
Defrauded
passed.
for 42 years.
For me, 42 years, but I have not been heard. No notice, no natural justice principle has been followed by the tribunals.
What is subject? But after 42 years, even fraud will vitiate. Fraud will vitiate everything, but after 4 to 3 years, reverse thing will happen.
Notice, please, my lord, other
Things
side may be heard.
survive after 42
I have been heard, not heard, please, my lords.
After 42, the generation changes.
No, I have no notice. I was in possession of the property, cultivating the land in question. I have been defrauded, please, my lord. 27/11/1974, I have been given the date of registration sale deed. Later on, the land tribunal grants an order in favor of the other side.
Third learned advocate, sorry, Mr. Third learned advocate, come with the betterment. Third learned advocate Vasudev Iyengar for the appellant. The challenge in this writ appeal is directed against order dated 21st June 23 of learned single judge, whereby learned single judge has dismissed the petition on the ground of delay and laches.
Laches.
Paragraph. What was challenged in the writ petition was judgment passed by the land tribunal.
Land tribunal.
The tribunal delivered its judgment and order on 5/10/1981. Also, the present petition is filed in the year 2023. Paragraph. It is evident that then 4 decades have intervened before the petitioner thought it fit to challenge the order of the land tribunal. The delay and laches have remained, not only have remained unexplained from a period of 42 years. Delay is too long to be countenanced in law.
I was not heard, please, my lord. I was not aware.
After 42 years, the right to seek relief in the writ jurisdiction were virtually lost. Learned single judge, paragraph, therefore, was eminently justified in dismissing petition on the said ground alone of the delay and laches of 42 years. This court does not see any reason to interfere with the said order. The writ appeal is dismissed.
This is number 19, Mr. V. Anand.
My lord, the writ petition is allowed, my lord, solely on the ground that I have to file a suit for declaration, my lord. In fact, my lord, I already filed a suit for declaration.
Your suit is pending.
No, my lord.
The entry is registered on the basis of registered deed. And the court, learned single judge, kept it open that after the.
Already I have filed a declaration and it's been decreed, my lord,
Decreed
against the
also?
vendor of the petitioner. My lord. Yes, my lord.
Decreed?
Yes, my lord.
When? Where is that?
Page, my lord, page. Uh, 140, my lord. 140. Please, my lord. Para 9, my lord.
Para 9.
Yes, my lord. It is submitted that the plaintiff hearing. May I read, my lord? Page 140, para 9.
Explain.
Please, my lord.
Where is the decree?
Decree I will produce, my lord. I have referred the matter and also they have referred in the sale deed of the petitioner, my lord.
Where is the decree?
I'll produce it, my lord. Decreed against the vendor of the petition. Ma'am,
In terms of this compromise has happened.
please, my lord.
So you
Is he a party to the proceeding?
His vendor was a party.
Third learned advocate, Mr. But then you did not point out this to learn a single judge.
No, I was the impleading applicant, my lord. I was not a party before.
Third learned advocate, Mr. V. Anand.
Please, my lord.
for the appellant, notice returnable. This can be kept on all point 25th, 23rd of April.
Lord, I take notice for respondent number
Learn and
292.
before that, learn and additional government advocate Ms. Nilokar
For two.
accepts notice for this one too.
Stay of the.
The private disponent shall be served before the next dispute. We'll dispose of on that.
Since number 20, appeal by government.
Lord, I appear for the appellant. Lord, the respondent number,
No, you are not heard before learning single. Notice. Heard learned additional government advocate Ms. Nilokar Akbar, notice returnable. It can go in the second week of reopening. Any day. Spread the date. Different dates.
Very, very different.
So number 21, appeal by government.
Lord, the Honorable Supreme Court in the case of Avinash Mehrotra versus Union of India. My Lord, based
Safety
on-
guidelines.
Yes.
This
My
is
Lord,
in-
now what has happened is,
Heard learned additional- Reopening first week. Notice.
28-5. So number 22,
My lord, I appear
Chief
for
Prakash.
the appellant. My lord, there was a partition between appellant and 1985. And my lord, the mutation was accepted by the revenue authority based on that partition. My lord, my brother, the fourth respondent, my lord, he challenges the mutation entry after 19 years before, my lord, the third, 19 years after the mutation. My lord, my brother, my lord, prefers appeal before assistant commissioner. Before that, the another brother, my lord, against same mutation, he filed appeal. And this fourth respondent was also party. And that appeal was dismissed.
So what is happening? 19 years, after 19 years?
After 19 years, my lord, he prefers appeal against mutation. It was confirmed by, my lord, the competent authority when that same was challenged by another brother.
Heard learned S.V. Prakash, notice returnable. Reopening first week.
notice for respondents 1 to 3.
1 to 3.
Learned additional government advocate Ms. Nilokar Akbar accepts notice on behalf of 1 and 3. 1, 2, 3. 1, 2, 3.
But I had the benefit of stay of, my lord, proceedings.
No, notice.
There shall be stay. Delay is there.
No delay.
No, there is no delay, my lord. There is no delay.
By way of paid interim leave, the parties are directed to maintain status quo with regard to the subject matter. Land is.
Land, my lord, but I wanted an interim order against, my lord, the appeal, my lord. Appeal, he would take up the appeal, third respondent.
For
My Lord,
consideration.
Yes, yes.
Order is dated 12th
That-
December
that-
2023. My Lord, I do not know the stage of the appeal, my Lord, before the Assistant Commissioner. My Lord may have this next week. I'll make my submission and then my Lord may consider.
Stay the proceeding.
Which role you prayed for?
Yes, prayed for.
Yes, ma'am.
Prayer is.
There shall be ad interim leave.
Before the assistant commissioner it is.
Yes.
Yes, ma'am. Page 58.
136-2.
136-2, my lord, the appeal. Page 58. ma'am.
By way of ad interim leave, the proceedings of appeal. pending before the Assistant Commissioner Shivamoga Subdivision, Shivamoga in PDA number 215/2019-20. Present state.
Okay, obliged.
Furthermore, the parties shall maintain status quo
Okay.
with regard to the subject matter property. Till the next date.
Obliged.
Both the directions will operate till the next.
Number 23, transfer property.
Lordship's kind permission.
Okay, what about?
So persons belonging to the
Covered by the judgment also.
Please, my lord.
Happened to other judgments.
the
The
Please.
judgment that has been followed by the learned single judge
Please, my lord.
is of learned single judge himself in other connected matters. What happened to those matters? Are they an appeal or they have attained finality?
In pursuance of the Supreme Court judgment, my lord, this, the learned single judge has passed the order, my lords.
confirm. Supreme Court confirm.
So that decision.
So you need to give.
My lord,
the
whatever,
benefit to all
whatever
civil-
petitions, my lord, whatever petitions they had filed relying upon the Supreme Court judgment, we filed appeal. All those judgments, only six petitions were clubbed together and passed even still pending. And those petitions, wherever it is relying upon the single judge order by the same judge, we filed an appeal before this court. These are all petitions come together now.
Appeals are still pending now.
No, this is the appeal, my lord. No, all those appeals are,
Only in this matter you have challenged that single judge, learned single judge's order.
no, all those petitions whichever disposed of by the learned single judge.
So these are the petitioners, original petitioner, who sought similar benefit.
No.
Yes, sir.
My lord,
Yes,
the persons who had gone to the Supreme Court earlier, they had come before this court before single judge 2017, 2020, writ appeal came, writ petition dismissed, writ appeal allowed, gone to the Supreme Court in 2013, 11th April 2023.
Decision of the courts shall have to apply to all identically placed persons.
That's correct, my lord,
irrespective-
but the
irrespective
only
whether
thing is, can it be
they are
retrospectively
before court
operational?
or not. That principle is laid down by the Supreme Court in three judgments. They need not go to the court again and again.
No, that is correct. They need not go to the court in one of the judgment, my lord,
That
justice.
is the only-
No, here it is what we are contending, my lord, kindly hear me.
Yes.
What we are contending, can the judgment be read as a retrospective operation? Here the people have retired 20 years back, 25 years back. Now they have come before this court by virtue of the judgment passed in 2023. A prospective overruling must be judgment, not cannot be a retrospective overruling. That is what my contention.
What my lord is saying is, where a service benefit is extended, given to one employee, one single employee, rest of the similarly circumstanced employees need not come to court. There is an obligation on the Article 12 entities to extend those benefits on its own without there being any
But
demand at
one
all.
judgment, my lord, what Justice, Honorable Justice Voka is cleared recently, said that those who have not come before the court cannot take the benefit of the judgment and come later on. That is, the judgment is there, my lord. I am not saying that.
You could note, if you give, we will be able to see.
Please,
that.
please.
Otherwise, how we can.
It's left hand, I am sorry, my lord.
It's all right, no problem. We don't differentiate between hands at all.
Last paragraph, para 12, my lord.
So here the court itself has limited the operation of it. Maybe in a different context. And that judgment is here, learn a single judge has referred to Arvind. Even some other judgments.
Other judgments are there.
Several judgments are not saying that the delay will not arise in the instant case for the reason it's an increment which has already been accrued and earned by the employee by virtue of his continuous service for 365 days.
This is the first July increment which.
It falls on 1/4. Increment falls in Karnataka, it falls on 1/4.
So, my lord,
The employee is
In this matter, my lords,
Employee is retired on the previous day. Same.
yes,
true.
Then this is the clear, this is confirmed on Supreme Court.
Not that is confirmed. What, my lord, I'll say that. I'll quote your lordship. Let that be judgment be read also. I'll quote that, my lord. I have given it everything, even in the.
Specific. Displaced out.
And we dispose of number of matters in
Same, similar lines.
Gujarat High Court. And there also government wanted us to wait.
Not one judgment is there, that is.
Central government has already implemented the order to all the departments, not based on the CP Mundirmani's case. They have already been concluded issue.
Once there is a law laid down the Supreme Court, you have to follow.
Kindly
Excluded section.
I kindly appreciate these things. I have raised 4 grounds, Lord, in my writ appeal.
Yes.
Even in the writ petition, whatever I have raised those things, my lord.
Yes.
If he similarly situated, I'll coming to first the judgment only. Lord, I'll pass on the judgments. Lord, kindly see one of the judgment says that the single judge considered only half of the paragraph. The paragraph follows, my lord, these are all the judgments. Lord, that is a prospective, your lordship knows very well, my lord, I
do not know that proposition which you are saying. I know the
We are
contrary
all teachers of the lordship, we know very well, but this is a forum where we have to be, it has to be decided.
Teachers of the law were pupils of it.
My lord, this is started Blackstone theory in 1932. My lord, they draw. Every judgment should be a prospective overruling. That is what my contention, my lord. Even in the latest judgment, my lord, kindly go to, it is followed by Supreme Court continuously.
Your lordship, I am for appellant.
Lordship. The second respondent authority has passed an order transferring 139 officers. Your Lordship, out of 139, 8 officers have filed a writ petition, Your Lordship. On 15/12/2023, the Honorable Single Judge has passed Annexure D orders, Your Lordship, in WP number 24/867, but on 23, Your Lordship. Your Lordship, in this case, the appellant and respondent number 3 have completed their minimum stay in their respective place. Your
But
Lordship.
how you are aggrieved with this order?
Please, Your Lordship.
You are one of the petitioner.
Here I am the appellant, there I am the respondent, Your Lordship.
So you are the original petitioner?
Yes, I am the respondent, Your Lordship.
Respondent.
Yes, Your
Petition was
Lordship.
filed by.
Since the respondent.
But even then, how you are affected by this order? Page 50.
Your Lordship.
How you are affected?
Because the respondent number 3 have completed the minimum stay, Your Lordship. I have also completed minimum stay in my place, Your Lordship. Since the division bench of this honorable court in Your Lordship, in Veena versus State of Karnataka. My permit. Your Lordship, page number. Your Lordship, page number 41. Para 8, Your Lordship. Furthermore, on thorough perusal of the paragraph 8, Your Lordship. Page number 41, Your Lordship.
41.
Yes. Furthermore, on thorough perusal of the decisions of this court, in MS Purushottam Reddy's case, N. Venkatesh case, and KM Prashant Kumar's case Supra, and are also, if exhaustively read, then this court has clearly clarified that any person who is being posted in a particular place cannot be allowed to continue in the same place for more than the tenure which is prescribed upon. If done, then the chance of him growing roots and also vested interest are more probable than definite. In this legal background, if the case of the petitioner are to be considered, keeping in view the findings recorded in Rajshekar's M case Supra, then it would be difficult for the state government to refer to
But
each.
your retention period is over.
Please, Your Lordship. I have been transferred.
Correct.
I'm not allowed to take charge because of the order passed by for Your Lordship.
Or learn at Ashok.
Please, Your Lordship.
For the appellant. Notice returnable on.
Stay maybe.
What stay?
The judgment of the Honorable Single.
It will
So
amount
far as
to
this,
11 years.
this petitioner is concerned, Your Lordship.
No, notice, after notice, let us see. Because it will be virtually amounting to partly allowing the petition at the appeal itself.
So after vacation, first week.
First. Please, Your Lordship.
Here for the land acquisition matter, we initially filed a writ petition on the ground that there was delay in passing of the award. The court rejected our petition. That writ petition disposed of in 2009. In 2024 also, my lord, the entire area was not developed. So I again came to court saying that the entire acquisition proceedings have been abandoned. Despite lapse of all these 2 decades, no development has taken place. And I also made an application for amendment saying that at least no compensation also is not given, at least give us at least developed sites. Learned Single Judge Muller dismissed the petition at the preliminary hearing stage, saying that you are filing successive writ petition and imposed a cost of rupees 50,000. Whereas Supreme Court has said that different stages we can approach the court. 2009 writ petition is dismissed on the ground that award is belated. And a single judge, my lord, does not even call upon the Urban Development Authority as to what development has taken. Entire area, 4 acres, is remaining vacant. Yes, Lord. Kindly see the judgment of the Supreme Court with regard to approaching the court. We filed a writ petition earlier in 2009 on the ground that there was delay in passing of the award.
Earlier round of litigation. And even thereafter delay of 12 years.
No, we are not challenging the acquisition now. We are saying that you have abandoned the acquisition proceedings itself because no development has taken place. And we also made an application or amendment. Kindly see the application or amendment in that page, which was not considered by the Leonard Singer judge. Alternately, we said at least according to, they have a scheme of giving allotment of sites in place of compensation. We have not received any compensation. We said that at least consider our case for allotment of the developed sites in lieu of compensation. Kindly see at page.
Any scheme is there for allotment of sites in lieu of compensation?
They have a scheme, of giving about 5,000 in per 1 acre. They have a scheme of allotment of sites.
Scheme is there.
Yes, Lord. 4 acres, they will give 2 sites of 4,000, 40 into 60.
So this 1980 scheme is adopted subsequently.
There is no modification. They have been making allotment.
Adoption is necessary, no? Otherwise we will be creating rights which the statute did not intend, number one. Number two, such schemes are, at least in one judgment, one of the judges of this court has held, the benefit of such schemes can be resorted to only where you do not challenge the acquisition. If you challenge the acquisition in multiple
In
times
this
up
case,
to the
my lord,
Supreme Court.
what happened was, the preliminary notification is on, my lord, the final notification is on 84. Now the award, individual award came to be passed in 2006 for nearly 30 years they did not pass an award. Then, my lord, on 7/5/2009, they deposited the check. Now, after this, my lord, my petition came to be dismissed on 18/8/2008. Now, after that, my lord, this entire proceedings, no development has been taken place. Possession also was not taken. I have produced the photographs. In identical circumstance, a division bench of this court has said that having taken over the land, not developing it for a substantial period of time.
Many litigations will be there. Nowadays, court has to take judicial notice of an avalanche of litigations pending before the court challenging the acquisition. You cannot develop the land in a piecemeal.
No, my lord, in this particular case, I am the owner of this 4 acres. No other litigation is there in respect of this 4 acres of land.
Scheme covers larger area.
The scheme provides for a larger area, but this 4 acres of land, nowhere, no litigation in respect of this after 2010. And the Supreme Court, my lord, has held, kindly see the judgment of the Supreme Court, that a party owner is entitled to come to the court at different stages. It's a different matter whether the court accepts whether contention or not. But the learned single judge finds fault with the fact that you are filing, every petition is produced along with the writ petition. Kindly see, my lord, at page 193 of the compilation. 195. At paragraph 15. at page 200, relevant page, paragraph 15. The issue needs to be examined from another. Page 200, para 15. The issue needs to be examined from another angle. A person who is deprived of his land can challenge the acquisition proceedings at various stages. He can question the notification issued under section 4(1) on the ground of violation of the mandate contained therein, like publication of the notification in the official gazette, and or 2 newspapers, including the one in the regional language, and failure of the collector to cause public notice of the substance of the notification to be given at convenient place. He can challenge the declaration issued under section 6(1) on the ground of non-compliance of 5A1 or 2 or violation of first proviso of 2 of 6(1). In a given case, landowner can also challenge the notice issued under section 9, award passed under section 11 on the ground that he had not been heard or that the acquisition proceedings are a nullity. He can also challenge the award if it is not made within the period prescribed under 11A. The vesting of the land in government can be challenged on the ground that possession had not been taken in accordance with the prescribed procedure. The invoking of urgency clause in section 17 can be questioned on the ground that there was no real urgency. There may be many more grounds on which the landowner can challenge the acquisition proceeding. In so far as the appellant is concerned, he had challenged the acquisition proceedings immediately after passing of the award, pleaded that declaration issued under section 6(1) was liable to be declared as a nullity because of violation of time limit in the first provision. This being the position, it is not possible to approve the view taken with the division bench. Then, my lord, at page 114,
This is a general delay in challenge. This is in context of the time
No.
period to be observed between 4(1) and 4(6) notice.
yes, but the question is, if the proceedings have not been developed, kindly see page 114, my lord. The division bench judgment in identical matter. Page 114 of the compilation. At relevant page 131. Paragraph 17. In the instant case, the facts are very pertinent. Para 17 at page 131. Though the preliminary notification was issued under 28(1) and 25(8)71 and declaration and final
That
notification.
was a
under-
case where no award was passed.
But
Possession was taken,
no,
but award
in
was
this
not.
case also, my lord, they say that there is abandonment of the acquisition process by the state government as well as the acquisition as the RAPS, the abandonment of the for over 4 decades from the date of taking possession. No award has been passed. In question, no award has been passed. No compensation has been awarded to the landowner. That is also, but the concept of abandonment is also there. Then, my lord, there is the division bench judgment of this honorable court at para 98 also. This kind of creation of land bank, my lord, is not permitted at all. They acquire the land and just hold it on without developing the land at page 109.
But that ground was available to you at the earliest point of time when you were before the
No,
court
no,
and
the
before the
fact-
apex court also.
The fact that the land is not developed for a long period of time also gives me cause of action to come to the court. The learned single judge, my lord, does not go to the merits of the matter. Learned single judge says you cannot file the second petition at all. The ground is Lord, I also made an application at page, Lord, kindly see the application for amendment which we filed. At page 121. At page 123. Issue a writ in the nature of mandamus directing restoration dated 18/8/21 for grant of developed sites in view of the land not being developed with the respondent authority till date. Now, whether this notification applies or not is another issue which they will have to examine. I am at least entitled for a consideration of my case, not according to this circular. If they say, no, no, you have gone to the court, therefore you are not, your case will not be, this is a different issue. Now having,
Different issue.
but,
It may be different issue, but it's a
no, but
relevant
that is
issue.
not there in this scheme. Scheme does not say so. It-
By the court, one learned judge has said that way.
Lord, the question of consideration of this prayer is not done at all by the learned single judge. This application or amendment is not
But
considered.
unless you prima facie show that scheme has been made rule of binding, rule of conduct by adoption, etc. That's where are the pleadings to that effect, even the one which you have read now. That does not say in so many words that it has been adopted, may be adopted. Kindly see the terminology.
Lord,
of
here
the-
the respondent was not even called upon to answer. It is rejected at the threshold. Now, the question is whether they will have to answer whether this is adopted, if it is not adopted. If it is straight away rejected at the threshold without examining whether this is adopted or not, my lord, I would be adversely affected in this proceeding, because now 2009 is the acquisition. Kindly see our plight, my lord. Land is acquired in the year 1984. Amount is deposited in 7/5/2009. That is, my lord, nearly 20 years thereafter. Now, till date, it is lying in deposit. Now, in a case, my lord, in a case where the landowner has not got the money till date, is he not entitled to make a request that at least consider our case for the allotment to the developed site? The delay on the part of the award, the individual award is passed, kindly see page 93, on 24/8/2006. That is nearly, my lord, 84, 94, 2000, 20 years thereafter. It looks as if, my lord, that the landowner can be taken away, land can be taken away without even paying the compensation within the period of 2 years. No doubt I have earlier lost. The court has rejected our earlier petition. But this is a relevant factor which should be taken into consideration. Kindly consider, my lord, that at least they may consider our representation for you appear.
I appear for respondent number 1, my lord.
Your lordships are holding against us. My lord, why impose cost of 50,000?
Cost is imposed.
Cost of 50,000 is imposed.
Very. But then why don't you tell that you are filing this appeal only for them in the beginning? It so appeared to us. You are entitled to argue. The cost is deleted.
Number 26, appeal by government.
My lord, in this matter, my lord, I apologize, my lord. My lord, the file has been misplaced in the office. If my lord could grant me 2 weeks' time, my lord, I apologize. Obliged.
But it is covered as such.
My lord, I've got the citations. I will produce them.
All 2 weeks.
Number 27, so Patil Dayanand.
I appear for the appellant's counsel.
You are not party.
I'm not party. After a long line of litigation, ultimately this honorable court directed to issue occupancy certificate to us, where without making us a party, as an interim measure, all these things is being done.
This is against an interim order.
This is against interim order.
Yes.
Yes, there is an interim measure, more than the final relief. Kindly see the
assuming-
final relief in the writ petition.
We'll assume that it's a final order.
Please.
In Shivdev, 63, so 63,
We
63,
can-
63 Supreme Court. by judgment decision. Their apex court suggested.
We,
And,
we
Justice
we
Swami.
could have done that, but
Justice Swami, before whom you had argued.
maintained the petition till now. Therefore, I normal court, fresh writ petition.
Workmen. You all are workmen.
No,
No.
we are the persons, farmers who were in occupation of this property. We applied for regularization. Regularization is granted.
But they are settling among themselves.
Huh.
They are settling amongst themselves. This thing.
Or no, we can't grant unless we have a delay. Notice second week of reopening.
Lord, I take notice for respondents 2 to 6, my lord.
2 to 6 accepted by.
Twenty-eight, Mr. Chandrakant Argument.
My lord, petitioner, my lord.
Hearing for the statement.
The charge number 4, my lord, has been held to be not approved, my lord. Your lordships, no doubt, my lord. You oblige.
Second week of
11th June. Still number 29, Mr. Madhukar and Deshpande.
For the petitioner, my lord. There is one subsequent event, my lord, which I want to place it on record to seek for the review of the order, my lord. With respect of the third phase, my lord, the circular has been issued by the university and the college also has issued the list of the students who are required to pay the fees, my lord. The stand of the college before the writ court as well as before this honorable court that I have not attended the classes. With respect of that particular stand, my lord, it was my submission was that I have attended. That particular submission, what I made before this honorable court is vindicated by issuance of this circular, my lord. I have been called upon to pay the fees for the third phase.
Where is that?
Yes, my lord, I am just placing it on record.
Then you should have put, these are
Sorry,
our
sorry.
problems.
Yes, my lord.
You should have put all that in,
that-
otherwise how we will decide? We will decide the things based upon the material
Yes, my
on
lord.
record.
That was subsequent to the passing of the order by this honorable court, my lord, and I'm just placing this particular circular.
Which you could not,
It-
it has
it
been
was-
issued later.
Yes, my lord. And subsequent event I can place with respect of review petition, my lord, that is my submission, my lord. The circular, my lords would find at page number 2, my lord. And my name can be seen at page number 3, my lord, at serial number 15.
Your name is also there.
Yes, my lord. Serial number 15, my lord, page number 3. Batch as on 12th March 2024.
But result has to be, but this judgment comes in the way of your taking
Yes,
up all those.
yes. I will serve the copy on the advocate who are appearing. Yes,
Our learned advocate. Madhukar Deshpande.
yes, ma'am.
For the review. Notice to the. Take this 22nd April.
Much.
When the examination will come?
My lord, the exams, I have already appeared, my lord. My
Oh,
result
yes.
has to be declared. And then I have to appear for this particular course, my lord. There is some urgency, my lord, but if before say vacation, my lords are fixing it is.
So this
I will
be
serve the
over
copy on
once-
it.
Like, this is likely to be over once other side is there.
Yes, my lord,
The
it can
other
be.
side
discussed.
comes, you can, because of circular.
Yes,
So it is open to the learner, to the petitioner, review applicant to serve copy of the application to
Council.
learned counsel who normally appears on behalf of the university
yes, yes,
in this court.
yes.
Into the compass of the controversy indicated by learned advocate for the review applicant, put up at 2:30. 22nd.
Lord, I pray for this time. Filing contempt, Lord, so far as aided period, this is pertaining to Act 7 of 2014.
The bench is considering.
Yes, yes, Lord. The bench is considering in writ appeal number 2476 of 2015. And so far as aided period is concerned, we have made the payment.
Which same similar matter was argued before us other day by you. Which is that matter?
That I will ready.
Institutions. Even state aid. That should be counted. So just of this code. The aid service should be counted. Station. Special. Formal notice.
Yes, please.
Notice
This may-
is ordered.
Notice is ordered.
Notice is ordered, Lord. This may be tagged along with 247.
List after
Disposal of special bench matters. It's a special bench where
Yes.
I am also
Yes,
one
sir.
of the members.
give Mr. Number.
Yes.
Since the outcome of this
In the event that.
Lord, in this matter, my lord, on 18/3/22, my lord, order was already.
Aid service is counted and grant is made now.
Yes, my lord.
So pre-aid matter is being considered by the special bench.
This is not pre-aid, my lord.
No,
This
no,
is in
not
respect
pre-aid.
of.
We are considering identical matter. Myself and Laches have considered and dropped also. There are judgments where with right to revive these proceedings, depending upon the outcome of the writ appeals.
But this is
Where
pertain
Mr.
to
Lakshmi Narayana is also
stagnation,
arguing.
stagnation
the matter.
increments, my lord.
The same thing we have seen.
Lord, the government has already passed an order on 18/3/22, my lord. Only thing is, my lord, as per the order, my lord, financial benefits has to be released in favor of the complainant, my lord. That is the undertaking taken by the learned government advocate, my lord, before the learned single judge. 18/3/22, my lord, order was already passed, stating that petitioner is entitled for stagnation increments, 5 increments, my lord. That financial benefits, my lord, they have taken time. That has not been paid so far, my lord.
But we can't say that it is a willful default because the coordinate bench is special bench is considering all these aspects of the matter. In such cases, we can't say it is willful. It may be non-compliance, but not willful default. The contempt is founded on willful default.
or you withdraw with the liberty reserved to approach the court after the decision in that
Coordinate
390. What is number?
2476 of 2015.
Writ appeal.
Writ appeal.
2476.
2476 of 2000.
2015.
15.
Where 2014 Act is challenged.
Yes, 7, Act 7 of 2014.
7 of 2014.
Yes. What do you want?
After
Order
this-
or withdrawal?
But this may be called
Yeah.
after disposal of that.
Why should we keep this unnecessary pending?
Right to revive we are giving to you based upon the outcome of the proceedings. Similar matters also have done same thing.
Yes.
Identical matters, I remember. Identical matters we had said. Okay. Right to revive.
In this contempt proceedings, the actions regarding granting of financial benefits to the petitioner are sought to be complied with. The issue related to grant of 5 stagnation increments, which become due during the past service. Pre-aid service of the complex. Full stop. In course of the hearing paragraph, it was stated that substantive petition is filed, wherein the challenge is laid to a legislation at 7/2004 to Act number 7 of 2014, which takes away the right of the employer to get counted the services for pre-aid period. There is no gainsaying that the obligation on part of the authorities to comply with the directions in this petition would depend upon the outcome of the aforementioned process where the legislation is challenged. In that view, at this stage, it is difficult to hold that there is any willful contempt on part of the authorities in not complying with the directions. These contempt proceedings are closed. Observing that the respondent shall abide by the outcome of the division bench judgment in which is the number?
2476 of writ appeal 2476 of
Yes,
writ appeal
number 2476 of 2015
and 2467 of 2015.
As well as 2467. Writ appeal number 2467 of 15. With the aforesaid observations and reserving liberty for the applicant to revive the contempt proceedings in case of necessity. Present proceedings are not entertained at this stage. You are protected from all purposes.
I appear for the counsel for the complaint, the content proceedings, Lord, the writ appeal, respond number 1.
Lordship, I appear for the appellant, Lordship.
But I have filed this IA for modifying the interim order or vacating the interim order. In the present case, my lord, respondent 1, the appellant invited application for tender, supply of my lord 3 items in the year 21. ICU code 628, portable X-ray machine 165 number, syringe pumps 625.
Who appears for the respondent accused?
Hello, in the writ appeal, that's 31.1. I'm appointed as a special government counsel. I represent respondent number 2 to 5 in writ appeal, not in the contempt.
So,
Lordship, I appear for the.
Yes, my lord.
Lordship, I appear for the appellant, Lordship.
I may be granted some time to
Lordship,
file my
in
response to the.
But I is posted 2-3 times, Lord, it is not reached. Matter pertain tender. One or other way, my lord, I request your lordship, my lord, pass an order. But two items are concerned, supply is already not you given to others. Only one item, my lord, is concerned.
Correct, but appeal has to be heard, no?
Yes, ma'am.
It
True,
has to be
true,
heard
my lord.
along with this.
Yes, I request your lordship, my lord, let the IAB like that, my lord. Understanding, my lord, a date may be given to them to hear it, my lord. Very short matter. I will not take more time.
The panel council, Sumana is panel council.
Yes.
Please, lordship. Please, lordship.
She's
I
for the
will be
appellant.
put, because of stay, I will be put to hardship.
She's for the appellant, my lords.
Appellant.
Yes, my lords.
I will put to hardship.
But we request appellant, at least panel counsel should be personally present before the court because real hearing will not take place. Will not be meeting of minds between the bench and the bar.
Yes, it is inconvenient.
Of course, it's left
Yes,
to you people. Whatever you say, we will hear and pass the orders.
Lordship,
Yes,
Yes.
I know. My lord is right.
Physical presence is.
Yes.
My lord is right. One date may be given, lord, in the same stage, lord. I'm not.
lordship, any date, lordship, I am ready, lordship. Sorry, today I have some.
Requesting you to come here.
Please, lordship. Lordship, only
Distance
today
is
I
too
have.
much.
Lordship, only today I have some inconvenience, lordship, personal inconvenience. Otherwise, I always present before your lordship. It's a pleasure to argue before your lordship.
23rd April.
I apologize. Okay.
My lords, for the filing of
May I-
response by respondent number 2 to 5 as well, my lords. Time may be granted for the same.
May I make,
3rd April.
Yes, my lords.
may I make an appeal little earlier, lord? Possible.
Difficulty, many matters we have posted.
I know, my lord is preoccupied.
It's number 32, Mr. H.J. Karigar.
My lords, I appear for the petition of this case. Appear
Number
My lord,
32,
the
Mr.
non-compliance
Karigar.
of the order dated 3/3/2023, page number 18. My lord, sir, wherein while disposing of the writ petition, my lord, the honorable court has directed the respondent to pay sum of rupees 50,000 as a cost imposed. My lord, sir, short accommodation may be given. I'll be filing my wakalat today, my lords. The earlier council has issued as NOC, so I'll have to get my papers and instructions, my lords. Relevant page number 24, my lord.
So earlier 2 lakhs cost was.
Hello?
Earlier cost was 2 lakhs.
2 lakhs cost was imposed.
Yes, my
My
lord.
lord, despite of that, they come up with a submission saying that the private property is belonging to the government. Therefore, the another cost of 50,000 was imposed.
My lords.
You are for the authority.
Yes, my lords, for the accused, my lords. Earlier
Accused
council has
BP.
issued a NOC. I'll be appearing from today, my lords.
Even when 2 lakhs cost awarded, then also want to wake up.
Short date, tomorrow, day after, maybe granted, my lords. I'll get instructions and make the submission.
No, then we'll please the court. What prevents you to implement?
My lords, that cost can be paid. I'll insist upon them to have that paid today.
No question
Ready
is
to cost, but not ready to respect the court.
My lords, I have no instructions in this matter. I have no papers. I'm
This is not
handicapped.
the question, Mr. Council, about it.
Yes, my lords.
This is the only between the court and the council. You are not ready to comply with, but you're ready to pay cost. What kind of
My lords,
response you are giving?
I'm not aware of the facts in this case, my lords. I'm only asking for a small accommodation so that I can make.
Understand that for what of accommodation? Something to be answered readily by the council, that you are not complying with, but you are ready to pay the cost of 2,50,000.
My lords, I was only trying to be compliant here, my lords.
This approach is not appreciated.
I'm sorry, my lords.
Please come with concrete.
Yes, my lords.
16th of April.
Please. December 33, Mr. N. Kumar.
Lords, I appear for the complaint. Complaint.
In this matter, in this matter, the respondent accused was supposed to allot 21,371 square feet of cital area in lieu of utilization of the land.
Complied.
My lords, 90% of the order has been complied, my lords. There is one site that has to be registered.
That's out of about 18 sites. Only in respect of one site, sale deed is said to be registered. In respect of all other sites, sale deeds have been issued. That may require about a week's time. Within time, it can be closed also.
Within 1 week.
Please, my lords.
So something remains to be complete.
They have to execute one sale deed.
One
out
sale.
of
One
all
sale.
sale deeds they have executed. And he says within 1 week or 2 weeks, you will- within 2 weeks you do
Within
that.
2 weeks, we'll share.
What is sought to be complied with in this contempt proceedings is the directions issued by, where are the directions? Page 10?
11.
11. Issued by learned single judge in writ petition number 13462 of 2022 and other allied petitions. Full stop. When the contempt application comes up for consideration, our learned advocate, Miss, what is your good name, madam?
Samashrita, my lords. Samashrita.
Fairly stated that the directions are complied with regarding allotment of sites. However, she stated that in respect of one instance, the sale deed is yet to be executed. Full stop. In this regard, learned advocate Mr. Vivekananda
Yes.
made a statement that the sale deed, in the case where it is left out to be executed, shall be executed within 2 weeks.
2 weeks.
Full stop. This statement satisfies the complainant. Full stop. In the aforesaid view, the contempt proceedings are closed.
My lords, I request your lordship to keep the contempt proceedings open, because if they have not complied with the.
If the directions are not complied with, the respondent shall be exposed to aggravated form of contempt.
Please, my lords. Grateful, my lords.
Deeply approved.
December 34, Mr. Chandrasekhar P. Patil.
I am for complainant in this case, my lord. 34.1 may kindly be deleted, my lord. It is not connected to this.
Not connected.
Not connected. Last time your lordship said, but however, it is not. No, it has to be deleted from this.
Legend.
Extension in your care.
This is not connected at all with this. On the 34, we have to be here. 34.2 to be heard.
34 can be heard.
Sorry. 248 notices issued under the BBMP Act were challenged. Because please, 74D, please, that there was no, the zonal commissioner had to issue it, and he had not delegated, please, the delegated authority, please, was pleased to issue the notices. So 240.
Bangalore New Act.
Yes.
2020 Act.
2020 Act. But the rules were not framed only for the reason, please, that the writ petitions were allowed. In identical petition, 741111176, there is an interim order, and there are batch petitions which are ordered to be listed on 1/4, please.
Posted on
1/4.
10/4.
Connected. I have passed on the list, to the court officer.
10th June.
10th June.
10/6.
10/6.
This matter on 10th of June.
My matter is totally different.
No, No, this.
This matter can be called along, Lords, and the same at serial number 77.
34.1,
34. Writ appeal number 250, please.
that's what.
Yes, please.
That is not connected. To be listed with writ appeal number 286 or 24.
Lords, and all these matters, my lord,
Analyzed
the serial number
petition.
77 also, my lord, same order.
Involving the same issue on 10th of June, in the week beginning from, on 11th June.
Same order, my lord, so serial number 77.
77 also.
Same.
77 same.
Keep clear.
34-1 to be posted. Separate.
So far as 34 is concerned, my lord, the relevant writ appeal is 286 of 24. It is connected. However, it is on office objections. They are.
Which date is it?
That's serial number 34, my lord.
Which date?
The connected matter is with which date?
It is connected already.
Date.
Come up today.
34.2.
34.2.
It is there.
34.2.
Both may be listed on this 34 and 30.2, 34.2. Both being connected writ appeals involving the same issue to be listed to be listed on 11th June.
Both are not writ appeals, my lord. One is contempt and another is writ appeal.
This contempt with to be listed with writ appeal number 2.
And I may be permitted to take notice in writ appeal, my lord.
In writ appeal, you appear for the respondent.
Please.
Patil appears for the respondent.
And
Private
others.
respondent. Any state is also party. You have filed the state's appeal.
They have to serve a copy of petition.
Serve a copy of the appeal memo.
To be tagged along with the contempt and writ appeal.
66 of 2024. The party appears for respondents in the writ appeal. The writ appeal
286.
and writ appeal number 66 of 2024.
There I am not appearing.
It's a connected matter.
Please.
To be posted together. 16th April, yeah? On 16th. Entry model.
16th April. 35. Vaishali,
Coordinate with
Not
him.
in this matter.
I'll find out his timings. Yeah.
Pray
I'll
for
find out his
8 weeks'
timings and
time
I'll
for
discuss
this
with him
thing.
accordingly.
That this survey number 137 was acquired way back in the year 1963. We are securing the document, we'll file counter affidavit.
In the writ
The
petition, we had
direction is
produced
to
the acquisition.
remove
order.
the unauthorized entry in RTC.
There is a
Since it has
positive,
been acquired long back, this was not brought to the notice of the Honorable.
the acquisition notification was part of the writ petition, 1937 acquisition notification. There is a report.
This 137-1 is acquired.
Acquired to an extent of 2 guntas. That acquisition notification was a part of the writ petition. And the entire extent is shown as acquired. So the report was to remove that.
That's whichever orders they wanted to pass. We want to pass orders. See, so broadly, the mandate is.
Yes.
Point by the learned. Single
Yes,
judge.
I understand.
Even to consider that also, there is difficulty.
That he's securing now, that there are so many buildings are there. He's securing all the records from the corporation.
So positive direction, my lords, based on the acquisition notification.
Time.
Has taken
8 weeks maybe.
8 weeks.
Because of the intervening flood. Election.
Second week of reopen.
December 36. HP Gangesh Uda.
In this matter, my lord, we have received the proposal from the institution on 19/3/2024. We are, deputy director is going to pass an order, my lord, within 8 weeks. My lord. That the direction is to, my lord, the institution to send the proposal.
That direction was also for 8 weeks. July 2023. How many 8 weeks you want?
Lord,
Again and
the
again.
institution sent the proposal on 19/3/2024. That is, Lord, last week.
That institution is also party. Yes, my lord. Why they did brook so much delay? Who is the institution? Respondent?
D. Barmayas College.
Respondent number?
Respondent number here, in this case, 5 and 6.
Director, Pre-University Education.
They are the recommending authority.
Huh.
In this case,
In this case, my lord, I appear for the institution, my lord. Immediately after passing into the order, my lord, I have submitted my proposal on 2/8/23, my lord. 2/8/23 I have submitted. To Lordship kindly see. Thereafter, they have returned it saying that they have to send it in checklist.
2/8/23.
2/8/23. They said, my lord, I have to send through checklist.
When did you
I
send the
received the letter on, your Lordship kindly see, my lord. On 1/3/24, I received the letter.
To say that checklist has not come.
Yes. On 5/3, I have again sent the checklist.
Lord, the entire exercise will be completed. within
No,
a-
the question is not that. How many times the litigant, a successful litigant should hover in the court hall and in the court corridor? And we don't have any other job, only enforcement.
My apologies.
Last time what Honorable Varales have told the government and governmental authorities, we have made an order.
Yes, yes.
In contempt matters, in appeal we can understand. In contempt matters, if orders are issued for execution of order, implementation of order, recover of costs, for everything citizen has to come to court. Leaving all his job, they will be very poor people. Chief, unless we put some 5 lakh rupees cost, then they will wake up. This is the only language they understand. I feel they should be imprisoned, but anyway, we can now, initially we can.
What is to be complied with?
But is
The-
for
Her name has to be included in the grantee enablement.
granting it.
Such a small granting need.
grantee need list. She's an employee in the
Benefit of
institution. my lord.
granting aid has to
What
be
prevents you
extended
to-
to be.
What prevents you to do that?
Blood, for which blood institution has to send the proposal.
It sent it on 2/8. You returned it on the ground that checklist is not complete, pinning is not correctly done, the ink is different. What kind of, see the kind of, the Britishers were far better.
You show us the progress within 10 days, otherwise we'll go by what my brother says rightly.
Yes.
Will we go with cost? It is not that very many, it is not a task to be.
This is for obviously other regions, chief. We cannot say, because from here we cannot say all that.
So by 16th of April, you.
Please. Presence of the deputy director will be noted. He is present.
The disregard of the directions issued by this court. Appears to be blatant. However, as a last chance, time up to 16th of April is granted to the authorities concerned to act in terms of the directions and report concrete in that regard to the court on the next day. Failure will result into, the failure will compel the court to take a stern view of it.
Number 37, Mr. Suresh Babu BN.
I appeal for the complaint, my lord.
Lord, in pursuance to the order passed by this honorable court, Lord, I have given a representation to the BDA and BBMP, Lord. Lord, so it is pertaining to taking possession of the civic community sites which were relinquished to BDM, Lord. The work
To consider.
Consider, my lord.
That page 11 is the order.
Please, my lord.
Yes. What have you done?
Lord, we have, my lord, taken note of the parks and the open areas which have been encroached upon, some of which have been encroached upon. We have called upon the society to explain it. Our society has given a response to us, making some explanation. Now, my lord, we have to.
23 order is made on 13 July 2023. What are the things you have done? Show us from the records.
Your Department of Cooperative
BDA. Show us what is the plan, how you have done, how officers have done after, when you received this order, then when the pages were returned, when the order was read, when action started. We cannot go on telling stories to the citizens. They are successful parties. Even after, we are very sorry to say this. How many times they should come to court? Leaving, they have to cultivate the land. They have to go to workplace. They have to go to school to leave the children. How many times they should come to court? Once there is an order, why orders are not obeyed? Simple question. Only court has to spend so much time into ensuring compliance. These orders are made not by foreign court, by courts of the land. Your own courts or different courts.
As a
This attitude, chief, something has to be done. They understand only my
the
language.
last
8 to 9
indulgence,
months you are sitting tight.
Lord, as a last indulgence, I may be kindly granted a week's time, my lord. I will
Unless-
file a report, my lord.
I have a small submission. Unless some officer is arrested and detained in some room in the court hall, these things will not. We know these people. I really get disturbed, Honorable Chief. Kindly consider my anguish also. How many times? They are not captive citizens.
This is just you have to decide the representation.
Please, my lord.
You're just ignoring like an.
Every department.
Lord, the value of the property as on today is 400 crores, Lord. All they have allowed the encroachers to take possession and they're getting rents there and they have built the sheds.
Sir has to come. He should be on. Otherwise.
Who will be here tomorrow?
Lord,
because this is nothing to be done except deciding representation. And you are whiling away 8 months.
I request this, my lord. As a last indulgence time may be granted, we will file our complaints about it, my lord. I will not again seek time. The last indulgence, my lord. Any date as your lordship directs me, my lord, I will place it.
Today is what date? Today is
25th. Today is 25th, my lord.
20.
Some officer is
I
arrested.
understand.
By 28, you decide.
Please, my lord.
On or before.
Please.
Learned advocate, the order which was passed as back as in July 23, which was regard to the deciding the representation of the petitioner only, has still not been attended to, and the respondent authority of the Bangalore Development Authority has remained supinely inactive. Full stop. This tends to continued disrespect to the court, tending to contempt of the court. Full stop. However, we are persuaded not to take any stern view in view of the assurance coming forth from learned advocate Mr.
B. Vachan.
For the Bengaluru Development Authority that the decision on the representation shall be taken on or before 28th of March and shall be placed on record.
Please, my lord.
Full stop. Unless the statement is obeyed by the council, by the respondent, unless the statement made by the council is obeyed by the respondent authority, the commissioner of the Bengaluru Development Authority shall remain personally present before the court at 11 to explain the conduct.
Please, my lord. Oblige.
In fact, there is a,
This
based on the decision of this court in the contempt, Chief Secretary has issued a government order fixing the responsibility even if there is a delay in implementation of the order. There is a general order. In
Government order.
2023, I'll place it on record. This court directed contempt court, and based on that, there is a GO issued. That's
Even after first getting justice itself is very difficult nowadays because of so many factors, pendency, etc., etc. Citizen succeeds. And the fruits of the litigation, the success in the litigation would not reach the hands of the litigation, the litigant at all, successful litigant.
In fact, once your lordship fixes the time, it is a constitutional limitation as held by the apex court in the contempt jurisdiction. That this is a case where after hearing both the parties, an order has been passed, page 12, that these people should not be relieved from the post of principals. Now they have been relieved. That's the position.
Matter is still pending.
It is still pending.
Go and complain to the learned single judge.
It's a
that they have
violation.
Disobeyed your order.
Correct, my lord. It's a violation of the interim order.
We have consistently taken that.
Your lordships are right, but I only appeal to your lordship. Violation of the interim order is also the violation of rule of law.
True.
That's the position.
Correct.
Even if the writ is rejected.
Still
this
violation there can be.
Yes, this impunity would continue.
Correct.
The
But what
famous,
we have taken is, consistently what we have taken is, since it is not that it is not a contempt, it may be contempt, it is perhaps, but you have an alternate remedy. Because contempt proceedings, even in civil side, are treated as quasi-criminal proceedings. They are treated as quasi-criminal proceedings. Therefore, learned single judge is also available to you.
of
It's
course,
not
my-
that you are without remedy.
no, no, if it is a willful intentional disobedience, even if the matter is pending in Priya Gupta's case,
Correct.
the apex court said the contempt nor should proceed. The famous case in the Bombay 1997, where Municipal court granted an order of injunction. There is a violation. It went up to Supreme Court. It held no jurisdiction. Still, the apex court
Sorry,
said,
acknowledging that the order brought under contempt is interim order. Still, however, learned senior counsel, Mr. So-and-so presses the contempt, stating that even the interim orders could be subjected to contempt jurisdiction. Full stop. Admittedly, when the order is interim order and the proceedings of the petition are pending before a single judge, no final rights could be said to have been crystallized for any of the parties. Not only that, the nature of the order clearly indicates that it doesn't have any trappings of finality, which may persuade the court to entertain the contempt application in a given case. Full stop. In the aforesaid view, when the order is interim order and its nature is also remains interlocutory, the contempt jurisdiction is not exercised, the present contempt petition is not entertained. However, leaving it open for the complainant to approach a single judge to work out his rights and remedies in accordance with law. Disposed of accordingly.
Much obliged.
Number 39, 28 TS.
Yes.
Also, there's a delay of 618.
Hearing for accused number 3 months.
What is it?
Find after delay.
618 days.
618 days.
After 1 year.
Seek extension there.
Yes, your lordship, but because they have delay is there, your lordship, but
No, it is not a delay, it is the.
and more of only to consider the representations, your lordship, not pay protection was ordered by and the single judge has ordered to consider the representation only.
The order was
And
passed.
moreover, university has passed, has supported the contentions of the petitions, your lordship.
Order was passed by Laches single judge on 18th February 2020, requiring the competent authority respondents to decide the representation of the petitioner, which was in relation to the grievance about grant of pay protection, as was done to the similarly situated persons. Full stop. It could be immediately noticed that the directions as above were received in February, on 18th February 2020, the contempt petition is filed. In the year 2024, which was after 4 years. Paragraph section 20 of the Contempt of Court Act 1971 provides period of limitation to be of 1 year for filing the contempt proceedings, to be reckoned from the date when the contempt would be said to have been committed by the authorities. So the contempt was the contempt was committed and start running from the date of passing of the order. The limitation period stood terminated upon expiry of 1 year. For sick ground alone, we are not inclined to, we cannot entertain the contempt application. However, the complainant may have recourse to other remedies and thereafter approach the court in accordance with disposed of court.
System number 40, hearing on applications.
My lords,
May I please, Your Lordship, I'm
an
sorry, my lord, for
application
appearing
filed,
on
my
the
lords, by
VC
the
minute.
state.
I'm sorry, my lord, for appearing on the VC minutes.
Matter pertaining to the modification of this honorable court's order, my lords, where certain amounts were released for construction of the primary health center and the school, my lords, and now we have changed the survey number due to some reasons that there is a pit over there, my lords, which will take much more, around 3 crores extra cost. My lords, on the last date suggested that whether it can be given to Lokaayukta to look into it. My lords, the state has no objection, my lords, if it is the orders of my lords, because there are 2 orders. May I request my lords to look into 2 orders of this honorable court, my lords, the earlier order of 1999. 13th April 1999, my lords.
Their grievance was,
Please.
you have collected huge money from the particular people in that area. But now the structure which you want to bring for that PHC, primary health center, or what is that?
Please, my lords.
That is far away from that
No,
area.
that is
there
not their grievance. That is not their grievance. My lords, this is a writ petition in which certain amounts are deposited by respondent number 14, my lords, L&T Construction.
Correct.
2% of sale consideration. And my lords, there was a direction in the year 1999. My lords, that's what I wanted my lords to kindly have a look at, my lords. The orders of this honorable court dated 13th April 1999, my lords. And the matter was disposed of with these directions.
This very matter was disposed of.
My lords,
This very matter was disposed of.
please, my lords, the disposed matter, it's pending only for the purpose of, if at all we have to withdraw the money, we have to seek the permission of the court is what, my lords, is the direction.
13th April 19.
Please, my lords, page, in page 7, may I start, my lords? Second paragraph.
Page 7.
May I read, my lords?
Sub-register.
Page 7, sub-register, my lords. The sub-register Bangalore South Taluk is directed not to register any sale deed, mortgage deed, lease deed, or creating any charge pertaining to the flats, apartments constructed in these survey numbers or any portion of the land unless a certificate is produced to the effect of having deposited 2% of sale consideration in the State Bank of Mysore. the amounts so deposited shall not be withdrawn by the deputy commissioner. My lords may kindly mark this, by the respondents or the writ petitioners unless a comprehensive order is obtained from this court for the purpose of utilization of the amount for construction of a hospital, school, etc., for the benefit of the residents of surrounding villages. We further direct that the registrar of stamps and registrations will also monitor the registrations done in respect of the disputed property, so that the deposit of 2% is not escaped, and in any case where it is brought to the notice of the registrar of stamps and registration. My lords, the next paragraph, my lords, it's made clear that the 2% deposit kept in the fixed deposit as directed supra entirely belongs to the public. None of the respondents has any right over the said amount, as the respondents 8 to 12 have agreed to deposit the amount for the use of public for the surrounding villages. After the substantial amount is deposited, this court will appoint an independent body to supervise to fulfill the scheme or project like the construction of hospital, school, or any other facility to be decided by this court. And that independent body will be under chairmanship of the Deputy Commissioner, Bangalore Rural District, that will monitor the utilization of the amount for the said project, and after establishment of the project to continue its survival for future generation. My lords, the last next page 10, my lords, the final direction. The file will be kept in the custody of the registrar judicial as a special file and shall be placed before court whenever any application or petition is filed either by the deputy commissioner or the petitioners or respondent 8 to 12 seeking necessary direction for implementation of the order or any failure in implementation of the order. My lords, we have filed the necessary application, my lords. My lords may kindly now take 20th January 2013 order, my lords, where similar orders were passed and Lokayukta was made the monitoring authority, my lords. Para 5, my lords. 29th January 2013, my lords.
Paragraph 5.
Para 5 of the order, my lords.
2013.
Please, my lords. Again, it was moved in 2013. Para 5 of that order, my lords. 29th Jan 2013. The writ petition was kept pending only for the purpose of monitoring the deposit of 2% amount and to appoint an independent body for the proper supervision and utilization of the amount. Therefore, Lokayukta is appointed as monitoring authority and is directed to monitor the construction activities to ensure proper utilization of the amount and quality of construction. My lords, the latest order is 16/6, my lords. Even in this, my lords, para 5. Please, Lokayukta. They are monitoring the construction activities, my lords. And this modification only to the extent of change in the survey number because of the reasons mentioned in the affidavit, my lords. In the affidavit, my lords, on 16/6/23, my lords have ordered us to construct and release of 8 crores of rupees, my lords, for one particular survey number. When we actually started the construction, my lords, we found that it's
The dike
yes,
and,
please. And we require another 3 crores for filling up those. That's why we have identified a nearby place, my lords. That's the reason. This
So instead of survey number 156, you want survey number 58 of Gollahalli,
please, my lords.
of the same village.
Of the same village.
How many, what is the
Please, my
distance
lords.
between these
Yes.
two survey numbers?
Please, survey number 156, where the primary school is coming up, my lords, is 1 kilometer distance from the survey number 21, which was earlier given. And survey number where primary health center is coming, my lords, 3 kilometers.
What is the nature of structure you want to put up now?
Please, my lords, we have explained, my lords. It is a primary health center and a school, my lords.
Both school and primary.
School
health
and
center.
primary
Out
health
of the
center.
amount which you have collected
Yes,
at the rate
please.
of 2%.
Please, my lords. Now there is almost 11 crores still available, my lords. In that we are now requesting for 8 crores and ought to be released as per the 16/6 order, my lord. You also provided the Nyaya Mitra, the construction Nirmiti Kendra, my lords, has also given the calculation. The affidavit clearly.
Where is the report of the engineers or experts who say in survey number 156 or survey number 21,
Please,
these
ma'am.
things cannot be done?
My lords, annexure R1 and R2, my lords.
R1, R2.
R2, my lords. We have collected a report from Bureau Veritas India Private Limited, my lords.
Who are they?
My lords, it's an engineering firm, my lords, it's a proposed construction where we have taken the structural engineer's report. My lords will get it at page 34, my lords.
Government land.
Please, all the government lands, our land, my lords.
Structural engineers.
Report, my lords.
Opinion report.
Yes,
Your
please.
construction board.
For primary health center and primary school, my lords, government school.
No, another piece of land is at what distance?
It's 3 kilometers from the health center, 1 kilometer from the school, my lords. Now what we have identified. It's in the same village.
What Ramesh, what did
So
you say?
may I invite your lordship's attention to order dated 13th April 2012 minutes.
13th April 2012, which you have seen now.
No, I think your lordship has not seen that order minutes. 13th April 2012. Just this is a small paragraph. May I read it, miss?
2012, my lords.
13th April 2012.
Please, my lords.
Yes, miss.
Daily orders, my lords.
May I read it, miss?
Yes.
We had perused the orders dated 13/4/99 and are in no manner of doubt that the collection of 2% on the transaction was not intended to be used for rehabilitation of encroachers on Putenali Lake. Restoring lakes to their original state by removing encroachers therefrom is one of the primary duties of the state. All expenses must come from state coffers. We expect that proposals and plans for construction of hospital or school as pointedly envisaged in the said order shall be available within the next 4 months. So therefore, so long as they use it for the benefit of the villagers, I cannot have any objection, Miller. But if it is not the primary duty of the state.
That's all right. But
Yes,
that
that's-
will be benefited to the same village only.
Yes, and
Not some different village.
True, Miller. That's why, Miller, on the last occasion, I requested Miller that let the matter be examined by the local Ayuktha, Miller, because I do not have any, no, after this distance of time, I don't have any link with the petitioner, Miller. That's the reason, Miller.
No, what we do not understand is,
Yes,
it is not that government is not going to abide by these directions. Now the structural engineers say whether a particular land is fit for construction or not. The engineer said, survey number 21 and this other survey number, they are
if
not
it is
suitable.
within the
Therefore, do
with-
this on some other land. They are doing
Yes,
it.
absolutely no quarrel on that, Miller. If it is within the vicinity of that village, Miller, no objection. It's
Within the, not vicinity.
That's why,
within the
that's why
village.
on the
They
last
are
occasion, that's
expanding
why I
their
made it.
version. They are not expanding.
No, on the last occasion, Miller, I brought to your lordship's notice. One is in Kanakpura Road, another is in Banerghatta Road, Miller. That's
But
the
within
reason.
the same
whether-
village, same revenue village.
Gollalli village.
Bangalore consists of several villages, revenue
know,
villages. So in the same village, they are doing it.
It is for that reason I requested that Lokayukta examine that issue, Miller. That's what.
What is there to be examined?
Whether it is in the, within the same village,
Here
whether
it
it is
cannot
within
be
the same village is a matter that should be examined, Miller.
Do you still say that it is within the same revenue village?
Please, my lords, that is my affidavit.
You're like, I trust that statement, Miller.
So which land you are identifying?
My lords, now, we are survey number 21, 6 Guntas, Golahalli village. Survey number 156, 25 Guntas, Harinagar, Kotanur village, both are in Bangalore South. Bangalore South. Within 1 and 3 kilometers radius, my lords.
Within 1 and 3, maximum 3
Yes,
kilometers.
maximum 3, my lords.
Same village.
Same village, Bangalore South Taluk, my lords.
So this is the only thing.
This is the only modification.
We'll pass the order.
Great.
Great. I'm sorry, Miller, for coming on VC minute.
So the PIL.
Lords, my lords,
Then you don't have any further. That's what.
Grateful, ma'am.
Great.
Of the Juvenile Justice Care and Protection of Children's Act. My lord, the original order was by the Apex Court, my lord. Directing
These
that-
directions have been issued
Please, my lord.
pursuant to Apex Court decision.
Please, my lord.
No, the one which you are referring to.
Yes, my
which,
lord. It's,
that we can-
it's dated 30th July 2019, my lord. In this petition. What had happened, my lords, is that they were supposed to, the state government was to ensure that a permanent secretariat was to be provided for this committee. At that point, my lord, they had rejected the proposal that had been put forth by this seeking for the same, saying that the staff could be managed, the staff of Karnataka State Legal Services Authority could be utilized for that purpose. This honorable court in the order dated 30th July 2019 has specifically stated that that is not permissible. Specific staff is required in order to enable that committee to be.
So independent secretariat.
Yes,
is
my lord.
necessary. That
Yes,
is your prayer.
yes, my lord. My lord,
What
in
the
fact-
government said?
My lord, in fact, this court, my lord, has created a separate branch for the Juvenile Justice Committee, a permanent secretariat. Produce it along with my application.
That was pursuant to direction of the Apex Court.
Yes,
in
my
those
lord.
two
Yes, my
judgments.
lord. Yes. On 4th February 2022, this honorable court issued a notification establishing a separate branch for the secretariat to the Juvenile Justice Committee. That is in my application. It's in my application dated 16th August 2023, my lord, at annexure R10.
So now what is the relief? What is your
Now,
complaint
lord,
actually?
please, my lord,
Huh.
my grievance is that that secretariat has still not, the state
Established.
government, yes, my lord, the state government is required to.
What all it should comprise of?
Please, my lord, we have already provided a proposal. As per the proposal, they were supposed to do it. The error that they have done, they have issued an order. They issue an order saying that on 2020, saying that the appointment is to be done as staff of the State Legal Services Authority. What they were actually required to do is to say staff of this Honorable High Court. So as per the rules of this Honorable High Court, they are supposed to ensure the staffing patterns, which they have not done. Because of which, even as of today, there is no staff. In fact, today it is functional on the basis of staff taken
Drawn
from.
from,
Please, my lord, please. Because of which the effectiveness is affected.
Yes, actually, Apex Court judgment. Apex Court say the separate secretariat should be established.
So here, the staff is not of the High Court?
No, it's not been done, my lord. They've not done it, my lord. In fact, my application there is a letter that has been written to the Chief Secretary in 2022 June itself, asking them to make corrections, written by the Registrar General, my lord, of this honorable court, asking them to make corrections to the government order so that the staffing patterns and it can be done as per the rules of this court, which has not been done. At annexure R11 is the letter that has been issued,
So chairperson and members of all these committees.
no, my lord.
Ah.
What is required, my lord, is a deputy secretary, a section officer, stenographer, assistant, and if my lord has my application,
Page number?
page number 154 of my application may please be seen.
This is 23/3/2020.
Yes, please, my lord. This is the order that was issued by the government. But if my lord says the name of the post, the method of appointment. Method of appointment, they have said, as per cadre and recruitment rules of Karnataka State Legal Services Authority. Actually, it should be as per the rules of this Honorable High Court, my lord, not of the State Legal Services Authority. In fact, if my lord
What is
just for a
the difference between?
become the staff of the High Court, my lord may for a moment see page 158 of my application, please. It is a communication issued by the Registrar General of this court, my lord, dated 14 June 2022.
R11.
Pardon?
R11.
Yes, my lord, R11, page 158. My lord, in this we have sought, if my lord may see the next page, last paragraph.
This petition is by whom?
This is suo motu petition, my lord. In fact, my lord, what happened was that the Honorable Apex Court was seized of the matter.
We'll look into it. These are not the issues to be addressed on judicial side.
Please, my lord.
We'll seek the response. What is,
Can I get back to my law? Order is of the year 2019. Sometime it started, and then
the staff is to be appointed by the High Court?
My lord, the government is to issue the notification as per which the staff has to be
Under their rules.
Yes, my lord. But the staffing has to be as per these rules, my lord, by the High Court rules. They have to allocate the funds for the same. They have to ensure that is done. And thereafter, my lord, the staff will be of the High Court. My lord. The
They're not-
difficulty that is being faced, my lord, is that
They're not doing that.
they have not done that, my lord. In fact, the order was passed in 2019. The difficulty that is being faced, my lord, is that there is a Juvenile Justice Committee. It is looking into the aspects of monitoring and implementation of the Juvenile Justice Act. 4 judges of this Honorable High Court are on that, my lord, but they have no staff
Staff at all.
to assist them, which obviously would hamper their function in the way in which it would be taken forward. ma'am. That is the difficulty that is being placed.
You
In
are,
fact-
you are the penal advocate for High Court.
My lord, for the State Legal Services Authority.
Legal Services Authority.
Your legal service.
We are the member secretary of this Juvenile Justice.
Ex officio member.
Yes, my lord,
secretary.
please. And these difficulties were brought, in fact, my lord, in my application, there were several.
This is really something you have to respond. Altogether, a different mechanism in terms of appointment is applied.
Right.
For government, it may be normal thing, but for us, it is not abnormal, but we want our own employees so that the things are more smooth. That is the only idea. Otherwise,
And that too pursuant to Apex Court judgment.
Yes, ma'am.
There are two
Please,
judgments
my
on
lord,
this.
please.
so we'll thresh it out, but don't think that should be extensively debated in courtroom rather. So just bring out some creative, positive. Potential. After the reopening.
Lord, there are other directions that have sought for that. I can take it up on that day, my lord.
Let us share copy of the application so
Please,
that,
my lord, I have,
and speak to government.
yes,
There is
very well, my
no-
lord.
No China wall
Certainly not, my
between
lord,
the
certainly.
members of the bar.
Certainly
to
not.
say. can have interaction.
Especially not in this matter, my lord, certainly not. In fact, my lord, they have filed a reply. What they see is we are still awaiting instructions. That is why we have also brought it to the attention of this honorable court.
In the week beginning from 10th June.
What's
So
date?
we give the date itself, 12th June, 1, 2. That is the 13th June, Thursday.
Grateful.
It's number 42, Mr. Prasanna Kumar P.
Appearing for the state panel.
On the last date of hearing, after hearing the matter for some time, your lordship was pleased to opine that this requires hearing.
Kindly pass over, my lord. My senior is held up in court hall 2, my lord.
Already there is interim order.
There is an interim order. Your lordship may kindly fix a date so that this matter itself could be heard and disposed of.
Only difficulty that we are facing.
Operating?
Please, my lord, interim order is operating. Therefore,
Some of the parties have already retired. They've attained the age of superannuation. The matter of compulsory retirement where the matter was Leonard single judge remitted the matter back to the authority for reconsideration. Now, because I have retired, my lord, no, my retirement benefits also has not been dispersed. We are left in the dark. That's the difficulty that we are facing. Some urgency, my lord. My lord may kindly fix a date.
Having heard learned respective parties. Only one? How many? All the writ appeals.
all the writ appeals.
All the writ appeals deserves to be admitted. They are here were admitted.
Delay to be condoned.
Please.
Delay is there.
Yes, please.
They are in time because of COVID extension.
COVID extension.
They are in time because of all. Yes, so. Maybe listed for final hearing in the on 20th June. What interim order is operating?
No interim order.
There is an interim direction, my lord, is there.
Where is
Not to precipitate, there is an interim direction.
Only difficulty is, my lord, now that we have attained the age of superannuation, our
Where is-
retirement
where is-
benefits also is not dispersed.
Where is that interim order? In the same language we will continue.
Yes, the same language it is.
The interim relief granted directing the respondents not to precipitate the matter shall continue to operate during the pendency of the case.
It's number 43. Pundika Ishwara Bhatt. Pundika Ishwara Bhatt, 43.
Nobody is there.
Also. Number 44. Lady Ramana.
Appellants. Lordship, the appellants are challenging the order of the learned single judge where the 4 issues were combined regarding the retirement of the professors. So the issue related to this appellant is quite different from the other petitioners. Lordship, the issue for this appellant is whether regarding the discrimination of retirement age between the government college professor and professor working in university. As per the government, they have accepted the UGC regulations, but for the government colleges, they said the retirement age is 60, whereas for the university, they say it is 62 years. Now, your lordship, the issue related is at the apex court, where the apex court says that UGC regulation is mandatory, and there is an interim order passed by the apex court where the services are extended till 65. Your lordship, on 17/3/2023, the government took time to respond to the Supreme Court interim order. The government has so far not responded to the Supreme Court order.
The lecturers who are.
They are lecturers.
Yes, your lord.
Lecturers in government college versus lecturers in university.
University. They have the same qualification, the same rules and regulations.
Same issue is pending before the Supreme Court.
The Supreme Court is the issue regarding 65 years age is pending before, and the Supreme Court has granted the order. Those who had obtained an order extending their services, later on by the judgment of the High Court, their service were discontinued.
Who are before the Supreme Court?
Several states, I have produced the
same class of persons.
Same class of persons. And the government is taking time from. May I pass, your lordship, the interim order. There were several judgments, and there is a judgment of this court also, division bench.
University of Agricultural, Mr. Patil versus University of Agricultural Sciences.
Your lordship is right. Your lordship passed a judgment on that. Your lordship, that judgment, your lordship held that the state has got independence to legislate, but the Supreme Court has got a different view on that issue. They say that the state government should mandatorily follow the central government legislation, because if there is a conflict between the state legislation and central legislation will prevail. So, whereas in 2011, the Honorable Supreme Court, in case of Jagdish Prasad Sharma, which your lordship had followed, they said that UGC regulation is not mandatory. That, however, the Supreme Court in the same judgment confirmed that those states.
You do not need mic at all.
I can argue without mic. Your lordship, what the Supreme Court said in even Jagdish Prasad Sharma case.
Whether the judgment which I had scripted,
yes,
did it go in appeal to the Supreme Court? I'm not sure.
Your lordship, the crux of your lordship has not considered many of the issues which were not being brought to the notice, whereas the appellants and the petitioner
do you have number of that case? That was from Dharwad bench, I remember.
Yes, your
myself
lordship.
and Justice Krishna Bhatt's judgment.
I have made a compilation also of your lordship.
That judgment you have made?
Yes, your lordship. I have made a compilation of all the judgments.
Entry 25, state list entry?
Your lordship, the issue for the state is from 2020, they are seeking adjournments. And after the case of the petitioners before the appellants, here it was very simple. There cannot be discriminatory.
Which is that judgment? Dharwad bench judgment. Correct. Correct. That judgment. Which article gives a state to frame service conditions? Article 25, 24, 25, state list.
Your lordship, what happened was during 2010, there was a rippling effect throughout the country. Some state adopted UGC regulation, some state did not adopt regulation. Then the central government, in order to please the certain state, they passed an order saying that state can have their own legislation.
Which is that entry which gives a state to public service, state public service, this 40, entry 41.
Your Lordship, that case is now dealing from this group of petition. Now the issue for this consideration for this, whether there can be discrimination between the same faculties having same qualifications, same rules and regulations. That is the issue in this appeal, Your Lordship. Because that issue was pertaining to 65 years. And from 17.
You're not seeking an interim.
No interim order is sought for.
No sought interim order.
Cannot be granted.
Your Lordship, in terms of the Supreme Court interim order, I am seeking that, Your Lordship, the state government.
We will hear the matter and dispose of. We cannot
Your Lordship-
extend the period.
Your Lordship may kindly see the order dated 17/3/2023. The state government, to respond to the Supreme Court interim order, took time. Now it is more than a year. The faculties are not getting the salary. They are not either getting the pension. And there were nearly 280 professors who had obtained an interim order. And that interim order was stalled on February.
So you want interim order for extension of services up to 62 years?
Yes, because the Supreme Court says they are
That's so-
eligible till 65 years.
That Supreme Court order can be read only in an order in person. That can't be. And unless you independently satisfy us, and
Your
we are not,
Lordship, there is
and
an
we are
other-
not, and we are not going to be satisfied.
Yeah, Your Lordship, this court has taken note of that thing, whether to respond to the, Your Lordship may kindly peruse the order dated 17/3/2023. This court said that the government should respond whether that order can be considered or not. And it is a
If
really.
government is applying that order of the Supreme Court, it is to
free
your
to do it,
petition,
sir.
well and good.
But we will not.
But as a court of law, we are not granting such action.
Your Lordship, what has happened is now the Supreme Court, there is one more proof of writ petition. This honorable court constituted a special three-bench judge because there were divergent views. And that special bench now has to be reconstituted because I have other groups of petition, a special by the former Chief Justice and other two judges, a special bench was constituted. And that special bench disintegrated because the judge retired, former judge retired. Now the bench has to be reconstituted in this. Here in this case, Your Lordship, the issue is very simple. The issue is whether there can be discrimination or not. Now the latest Supreme Court judge in the case where regarding the retired judges and of the High Court and retired judges of the Supreme Court, took there cannot be any discrimination. Because here these professors have same qualification, and what has happened is there were one more group which the college later on.
That may be a matter of final relief if you succeed that such a relief at the end.
Your Lordship may kindly at least fix a date and dispose because the issue.
They are bound
We
to
are
do that.
agreeable.
Bound to do that.
If you permit us, we will fix a date.
Your Lordship, what happens is if the date is not fixed.
We are fixing
6th of June.
6th of June. Be ready.
I have made a conscious compilation of all the judgments. And in fact, the 65 years, why I will take one last minute because the bench is now to be reconstituted. The issue is whether 65 years should be granted, whether the state has got mandatory power to lay legislation, whether the state should not continue. In this aspect, the Supreme Court has admitted and granted stay. So when the matter is pending before the Supreme Court, for consideration of this issue, whether 65 and they have extended the service of the faculties, those who had interim order, but the order came to be rejected by the High Court. Later on, the Supreme Court said, reinitiate them and continue their service. Your Lordship, what has happened is the faculties now, the senior experienced professors are required for the reason they were provided with some facility to do the PhD degree, and the government of India has sponsored them money, and they have completed PhD. By the time they completed PhD, and the service has been terminated. The service cannot be. That is the reason why the Constitution framed a law that these faculties should be used because they are experienced. They have been provided with money. They have been provided with 2 years leave to do the PhD, and they have done PhD. And after doing the PhD, their service because of the conflicting views.
Today is not 6th of June.
I'm one of
What
the
has happened
respondents.
is
You should not see, the clock is crying that you are not seeing it.
Your Lordship, what
See
has
the clock.
happened is-
Kindly see the clock.
From one year, I'm experiencing this.
Kindly see
Teachers
the
at
clock.
5 o'clock, I will not get the opportunity. The senior counsel will argue and I will not get the.
So you reserve your energy
I'm
and
one of the
arguments,
respondents.
everything for 6th of June.
My lords, one submission, my lords. I'm not for a UGC. My name is shown for a UGC. I was one of the respondents in the writ petitions. And so far copies have not been
Extend out
served.
to
my
6th
lords.
of June, name of learned advocate.
ನನಗೆ they have not served copies on me, my lords. And the last time also I submitted.
He will give you, he is a good friend.
Much.
33.
Venkatramanappa was the respondent number 6 before the trial court, my lord. He died during the pendency of the writ petition. Now his LRs, who are the appellants number 2 to 4, have filed application seeking leave of the Samla court to prosecute the above appeal. Venkatramanappa got the property as per the partition deed of 1964, man.
They died after the judgment.
No, before 2014 he died. Venkatramanappa died prior to this one passing of the order by the learned single judge.
His
Even-
LRs were, they died during the pendency of the writ petition.
Please.
Their LRs were not brought on
Not
record.
brought on record. It was stated even in my, I was the respondent, one of the respondents. And application, the respondent number 5 is the son. And before the trial court, before the learned single judge. And he was the 6th respondent. And in my statement of objection, I have stated so.
The fact remains they were not brought on record
Not brought on record.
in the court below.
Please, ma'am. Before the learned single judge.
Who's heirs? Petitioners.
Appellants, heirs.
Appellants.
Heirs
Please,
of the appellants.
please. That is the, who of the fifth respondent died, my lord. Fifth respondent.
This is your application, appellant's application. Application is by the appellants now.
Please, my lord.
LR applications are
By,
yours.
please, we are the respondents before the learned single judge.
Correct.
LR were before learned single judge.
Please,
Application will allow.
please.
One, two.
So INM 2 of 23. Third learned senior counsel for the appellants. Full stop. The appellants in this interim, the applicants in this interim application are the heirs of the deceased.
Appellant number? Deceased appellant, only one appellant.
Please.
Deceased appellant.
He was the 5th respondent.
Who died?
5th respondent before the learned, before.
Name of the deceased.
Venkatramanappa.
Of
Venkatramanappa.
the appellant Venkatramanappa, who died. Death certificate is there?
No, my lord, it is stated in my statement of objection before the.
Died on?
That is 1/6/2014. 1/6/2014 at the page number 122, a copy of the statement of objection, it was stated.
The statement of learned counsel regarding the date and the spectrum of death of the appellant is accepted. The applicants are the heirs who seek themselves to be joined as appellants to continue the cause of the deceased appellant. It is not in dispute that the applicants herein were the parties, the Polana single.
No, they are not.
They were not parties.
They were not party.
No LRs were part. Order is passed in absence of the LRs.
I thought that they were party.
No.
So we can't amend the title of it for the. Are you disputing the full stop? The applicants are the heirs of the deceased appellant. It is true that they were not the parties to Colonna single judge. As said, so and so died. Though the said so and Venkata Ramappa died during the pendency of the proceedings of the petition before Colonna single. Paragraph. The appeal is perceived as continuance of the writ proceedings. In that view of the matter, and also in light of also having considered the submission of learned additional advocate, additional government advocate, Ms. Nilofer Akbar, that she has no objection if the heirs are joined. Heirs of the appellant are joined in the present post. The present application deserves to be granted. The applicant shall be brought on record in the capacity of the heirs and legal representative of the deceased appellant so and so and so. Post title shall be amended record.
Please.
Application. What about main matter? Some other day?
Number 45, the Karthikeyan BS.
Matter. Complaint in this matter, my lords. So, two impleading applications, one, my lords, one indulgence, my lords. Can I file one application, impleading application? Respect of
There is a delay of
61 days. 61 days. That may kindly be condoned, my lords, due to administrative reasons. And also, my lords, IA number 3 of 24 and 4 of 24, seeking dispensation of the typed copy of the annexures, my lords. The translated copies have been placed on record, my lords. The typed copy has not been furnished.
Approval of layout.
Yes, my lords. My lords, in this matter, I may be permitted to file one application for impleading. Lords, where the property was reserved for establishment of a club. Lords, it is in the report of the BBMP, where, my lords, one plot was reserved for playground as well as for establishment of a club. Lords, there was a recommendation by the authorities to form a club, my lords. Lords, in view of this, my lords, I may be.
You represent the club.
Club, my lords.
It was earmarked for that only.
Yes, my lord.
Park.
Yes, my lord.
So I appear for the respondent number 1. In fact, I was the petitioner before the learned single judge. Let the copies be served to me also. But the issue is only
Now that public amenity area is being converted into for the purpose of.
My lords, now, my lords, plot number 11, where it was identified during pendency of the proceeding before the PAL, my lords, it was reserved for playground and as well as establishment of the club.
In the
Now,
plan itself.
Yes, my lords, not plan itself. My lord, there was a report submitted by the BBMP.
Yes.
My lords, before the earlier public interest litigation. My lords, now they have developed the said as a playground in a portion of the land and retained some portion, which is now for establishment of a club, my lords. There is a recommendation by the authorities.
But the issue.
I have filed application.
My lords, for the authority BDA, my lords.
Your BDA.
And I'm for the house building cooperative society.
You are for the petitioner society.
Society.
Petitioner society.
Yes.
I have filed application completing my lord since earlier plan my lord.
Objection. Short delay.
Delay may be found on.
A number 1, my lords. 1 of 24.
It is 61 days.
Yes, Lord.
Heard, learned and advocates for the respective parties. This application is filed, trying to condone the delay of 61 days, which has occurred in filing the present writ appeal. Full stop. The accompanying affidavit explains the passage of time leading to delay. The reasons are stated to be administrative. Time was consumed in processing the file. Full stop. Since the appellant is an authority, consumption of time in the decision-making process is inherent to some extent. Full stop. Certain leeway, therefore, is not impermissible, viewed from all the 10 points paragraph. Sufficient cause is made out to condone the delay of 61 days. Delay is condoned, application.
My lord, I have filed IA number 2 of 2024, my lord, for seeking implement of the applicant as a party respondent. In view of the earlier, my lord, my site, mine is the corner site, my lord. The subsequent revised plan has been submitted by the first respondent. That is, road has been counted as site number 18A, my lord.
The public road itself is
Yes,
now
ma'am.
given
Yes,
site
yes,
number.
ma'am. Yes, ma'am.
They may not be a necessary, they may not be a necessary.
No, no,
Not
Apex Court said they are all necessary parties.
Not
We'll
They are proper
consider-
parties.
This
Not-
will
It's
consider
afterwards.
afterwards.
One more application is.
My lords, I'll
You
file
have
it.
to
my
file
lord.
it in the.
I'll file it in the
But then-
registry, my lords. A date may fix, my lords.
Not a-
One application is pending.
Order 1 to joining file. Who are you? Who are the applicant?
But I am the purchaser of the site, my lord.
Purchaser.
Purchaser of the site, my lord. It is a action site, my lord, that is corner site has been
That's
actioned.
main-
So IA
may-
number
may-
2 of 24.
may make good
So the
submissions.
applicant here seeks to implement himself as party respondent 3. He stated in the affidavit filed by the applicant in support of the prayer that
Yes, my lord.
what you have purchased?
Site, my lord. Site, my lord.
Who concerns that site itself? Minutia of the road is- They put it in public option. Will have the vote of this particular bit.
That he has purchased the portion of the land, which is subject matter of the
Not
dispute.
issue.
in the
But I
Municipal.
have put up construction in the year.
It is further
2011.
stated that the paid portion is likely to be auctioned.
Yes,
No,
my
no, no,
lord.
no,
And
not auction.
They have
Not
given
auction.
option for me to
No, no.
invest from the northern side of the property, my lord.
Full
BPMP has
stop. Since
approved
the
it.
appellant, since the applicant has purchased the part of the land, it could be said to be interested in the outcome of the process. Full stop. The applicant is at least a proper party, could be permitted to be joined in the
But
process.
the issue is only
According-
pertaining to approval of the layout plan.
Permitting
You are
the
only
applicant.
petitioner, respondent. How
I'm
can
the
you
petition-
oppose it?
Not, I am the petitioner, not.
My lords, I'll file it in the office, my lords. I may, my lords, a date may fix, my lord.
To be implemented as parties full 3. Application is allowed.
May be permitted to carry out the
No,
some
not
office
at all.
objections. Some office objections are there in that.
The IA.
I'll permit it to.
So then when shall we list the matter?
My lords, next week, any,
15th February. 15th.
much. I'll file it in office.
15th
April.
Symbol 46. Ready notice matters. Just
If I may please your lordships for the petitioner. My lord, my grievance is the IPC under chapter 9A prescribes electoral offenses that include undue influence and bribery during elections, and these are non-cognizable offenses. A vast number of officials are deployed by the Election Commission during elections who don't recognize this distinction. In the absence of specific guidelines by the Election Commission,
to its officials on how to deal with a non-cognizable offense. When an official would apprehend an offender, they would approach a police station and file an FIR, and the prosecution would fall flat. In their reply, the Election Commission has conceded to my grievance.
The Election Commission of India must have their own orders. They have their own orders.
You have
About
those
the-
orders?
My lord, we have issued guidelines. My lord, annexure R7, page number 100. We have issued guidelines to what are the steps the officers have to be taken in respect of non-cognizable offences.
These are under Article 320, 300.
My lord, 324. No, my lord, may I read, my lord?
Which?
My lord, page number 100, my lord. Annexure R7.
100.
Please, my lord.
So your reply,
Please, my lord, please.
100, yes.
My lord, I will read the second para, unnumbered second para in the page, my lord.
It has come to the notice.
Please, my lord. It has come to notice of the commission that due to inordinate delay in initiating action by the election authorities for a violation of election laws, the competent courts sometimes refuse to entertain the criminal proceedings when filed after a period of limitation prescribed under section 468, read with section 419 of CRPC. In some cases, referring such cases to other authorities for advisors has led to delay in initiating action. In order to avoid such procedural delays, the commission hereby directs all the election authorities that whenever they consider the necessity or are directed by the commission to initiate any criminal proceedings in any matter, the election authorities concerned should directly move the competent court in the case of non-cognizable offences and the concerned police authorities in case of cognizable offences without approaching or moving through the directorate of prosecution or any other such authority. The above direction shall be brought to commission with all the notices. Well, further, in 2025 annexure R28, the state head of the election machinery, the chief electoral officer, too has issued such a similar direction, my lord. And now, the my lord, translated copy begins at page number 104, my lord.
Circular.
Please, my lord. Apart from this, my lord, on 22nd of March 2024, Election Commission of India has once again reiterated directions my lord, may I pass on the recent instructions issued by Election Commission of India.
This circular is pursuant to the judgment which has.
Please, my lord,
annexed
please.
here.
Please, my lord, before that judgment, this circular at annexure R8 is issued. After judgment, my lord, one more instruction issued by Election Commission of India on 22nd of March 2024. May I pass on the instruction? My lord, my apologies, my lord, for not properly produced.
When he had sent a representation to you, why you did not reply? Why you drove him to the court unnecessarily, wasting our time also? You could have said, brother, we have done all these. We have put things in place.
That's true, my commission would have done.
You would not have come to court at all.
Please, my lord, if I were to submit. The Election Commission has restricted the whole issue to the state of Karnataka now. In fact, this is something that is plaguing the whole nation. And as we go into parliamentary election, the Election Commission would conduct the election under Article 324 of the Constitution itself. And the letter from 2012 by the Election Commissioner recognizing this distinction.
Is it state specific?
Please, my lord. Now they have made it a state specific issue. If the Election Commission be directed to instruct all officers of each individual states, or if I may be further indulged, if they be directed to publish a handbook, because the offenses are more in number and an ordinary official cannot be expected to understand what the offense is or what is non-cognizable or what is cognizable. So
But
if
Apex Court in at least 3 judgments. One is Mohinder Singh Gill, another is AC Jose versus so and so. Then the third one is Association of Democratic Rights, etc., 2002 Supreme Court held the orders to be passed by the Election Commission under this particular article, which my lord has mentioned now, they are treated as quasi-legislative instruments.
Please.
How can writ court direct to make legislation or delegated legislation? And even Supreme Court says court should not direct making of law, be it plenary legislation or a delegated legislation.
Please, my lord. In the last 25 years, if there were any electoral reforms, it was through intervention by constitutional
Apex
courts
court.
by the apex court.
Apex court.
My lord, I approaching the Supreme Court for a fresh reform is not the scope of this petition. There is a specific direction by a learned single judge of this honorable court to the Election Commission to take note of this issue, as well as various other high courts have expressed
But
an
in terms
opinion
of
that,
notification is issued now. Circular has been issued now.
my lord, now they have made it
They should
an issue
satisfy.
specific to the state of Karnataka.
How can you are concerned with state of Karnataka only?
Please,
A voter in you are voter in which state?
I am a voter in the state of Karnataka.
Generally, the voting rights do not transcend the frontiers of a state.
My lord, but the issue that plagues the present situation is they could publish this directive to all commissioners of each individual
They have
state
sent
is
it.
all my prayer.
They have sent it now.
My lord, this
They have
is
sent it.
to the election commission, election of electoral officer of the state of Karnataka. But then this is a principle that they could adopt for the whole country as we go into elections now.
How can you say our jurisdiction is confined to the frontiers of the state? Unless you extend our territorial jurisdiction to other states. What the apex court said in Mithu versus state. Apex court said High Court should learn to confine to the frontiers of the state.
My lord, I will concede, but even the circular
They have
is
done
very bald.
You mean to say Election Commission does not understand all those things
My
which
lord,
you understand?
The election
Because I
commission,
also,
the election commission does, but the thousands of officials that deploy as a flying squad who stand by the road, who apprehend these offenders, are not aware of the procedure to be followed. Let them publish a pamphlet at least.
You are saying that annexure R8 is only made applicable to this state? That is what you are saying?
My lord, no,
What
the
is your
circular
precise
that is
grievance?
being subsequently referred to is restricted to the state. The letter from 2012, which is at page 100 in the reply.
No, you are saying that some circular is state specific. Which is that?
My lord, that is the one that was produced.
chief electoral officers of all states,
All states.
100, page 100.
100 is all states.
Well, that is from the year 2012. If they could publish the same circular again, I'd be grateful. This is a letter from 2012 recognizing my grievance. And this is a 12-year-old letter.
That remains, IPC is 1860.
Please.
Should it be again and again promulgated by the parliament?
My lord, even if this
Yeah,
is
brother.
from the year 2012, I have produced
Only
5.
small lapse we pointed out. Now my lord has pointed out, it's not state specific. You should be satisfied with. Only thing is, they should have, as a constitutional body, they should have responded to your representation. They should not have slept over. They have not slept over. They have done something, but it could have been appreciated had you sent a letter. Brother citizen, you have sent like this. We have done like this.
That's true.
My lord, even if it's a circular is from 2012, I've produced a series of judgments marked as Annexure C in my writ papers that show. One is from the High Court of Madras, show the lapse of procedure by the Election Commission. This is from 2017, Annexure C1, my lord. Then C2 is from 2014. Even if there was a circular, it was never adhered to.
Lord, there is in the 22nd March 24 instructions, Lord, there is a direction to Chief Electoral Officer who is the head of the state in the election machinery.
No, he says, why only Karnataka?
My lord, it applies to all state, my lord, right, my
That you
lord.
could have stated.
Lord, that's true, my lord. Even the mistake in the instructions, Lord, that can't be treated as that we are implementing only in the Karnataka
If you
because.
make a statement, everything will be over. Make a statement that this will be applicable to all the states.
Lord,
Please.
that statement, Lord, I will
Oh.
take instructions, my lord.
That-
Lord,
2012 letter. We'll look after it.
This one, copy which is given. No,
Page 100.
page 104.
Even that is, my lord, that letter is preceded by the endeavor of the commission who has written since decades to classify those offences as a non-cognizable offences, my lord. I have produced those letters.
But chapter 9A
Please.
is introduced decades ago to
my lord,
IPC.
Please.
You have
92.
recommended to make them cognizable offences so
Please.
that anybody can set the criminal law in motion.
Please.
But that has not yet become law.
That's true.
It's in the wisdom of the parliament. How can we say you should, it should happen, it should not happen?
Please.
For the parliament to do it.
Even if the circulars are addressed to a particular state, it will have pan-India effect. They are the election commission of India.
That observation
They
can
are
be made.
functioning under Article 324. So is that a narrow perception?
May not have that.
Anyway, you make a statement so that things are, air is cleared.
That's what.
Please.
My lord, I'll concede to my writ petition if that statement is made.
When you will make statement? Day after?
Please.
Day after. To be listed at 2:30. Looking
Grateful.
to the, awaiting the. First April.
Please.
To be listed at 2:30.
Number 47.
Wait, please.
Either Prabhu.
Suo petition, my lord. On page
I
50,
appear for
my
the
lord,
Union of India respondent number 1.
there is, my lord, an order passed by this honorable court. The medical personnel, the alarming, my lord, shortage of the medical personnel to the extent of 16,500 in the state of Karnataka, my lord, prompted this honorable court to register a suo petition on page page 50, my lord, 50. My lord's order is found. This honorable court, my lord, instituted this PIL, noticing, my lord, that there is a shortage of 16,500 medical personnel. This shortfall is across 454 PHCs in the state, my lord, and the division is given that which category of staff, my lord, is in deficit in what numbers. The major issue, my lord, I wanted to highlight before, my lords, is page 52. In fact, the English version is, my lord, page 54. One of the reasons, my lord, that we diagnosed because the shortage is because the compulsory service of candidates who completed the medical courses is now dispensed with this amendment in place. May I pass on, my lord, this honorable court's judgment? With that requirement, my lords had passed a comprehensive judgment upholding the constitutional validity of this act. Now, because of this amendment, my lord, there is an alarming shortage of the staff. In fact, my lord, now what they say is only for sanctioned vacancies, these compulsory service extends. But what is that sanctioned vacancy, against whom, my lord, it is to be filled in? There are no guidelines. That is, my lord, one aspect. And lordships may see in this judgment that my lords had passed. On page 31, Lord, this act was, Lord, passed with a public purpose. And what is public purpose, my lord, is also enumerated. The translating the aspirations of the directive principles is what, my lord, the honorable, this honorable court said. And also, my lord, despite this, now, my lord, the effect of that judgment is nullified with this amendment. That is, my lord, the root cause for the deficit in the medical personnel, my lord. Around 40 odd thousand personnel are, my lord, in lack. 16,500 medical personnel are not employed. And state has not come out with an alternative, even if the compulsory service is now dispensed with. What alternatives, why this was done, what was the policy objective that prompted them to take this drastic decision, nullifying the effect of the Honorable Court's judgment, my lord, is not forthcoming. And because of which, my lord, this was, suo motu was 6/1/2024 is when, my lord, this suo motu petition was registered.
It is returnable.
You have already taken notice.
They have already taken. Where is the order for notice?
One other issue, my lord, if I may highlight.
You have taken notice.
Then
May I-
file your.
One other issue, my lord, I'm sorry, I'm flagging page 44. So that, my lord, page 44, my lord. Lordships may see 16,500 are only, my lord, the medical staff. In addition to them, may I, my lord, yes.
I appear for the respondent number 1, my lord.
May I read it with your lordships, my lord, page 44. Given there is shortfall of about page 44, my lord, ink page 44, which is a report published by a reputed agency, which was, my lord, the basis for registration of this suo motu PIL. Page 44, my lord, I am reading with your lordships the second paragraph. Given there is shortfall, lordships have it. I'm sorry, the letters are very small. Given there is shortfall of about 16,500 medical staff in the state, 723 MBBS, so-and-so pharmacists, nurses, assistants, and laboratory technicians, and so-and-so Group D personnel. As your lordships may see, the personnel down below, in fact, the D group employees and laboratory technicians and, my lord, the nurses and assistants are, my lord, the real concern, because they actually man the PHCs. Most of the times in rural areas and semi-urban areas. There is an urgent need for the state to address this shortfall by ensuring that verified individuals are fit for deployment, can find employment close to home. And there's a need to boost the setup. Now, in juxtaposition to this, my lord, they come out with this act, where, my lord, the requirement of compulsory service is dispensed with. This is an anathema to what, my lord, the report says. So therefore, my lord, the state may need to take a stand on why they.
Respondents are directed to file a response.
Short date, my lord, because the alarming medical issue, which is not.
First week of reopen.
Great.
Number 48, Mr. Ganpati Bhatt.
Respondent. This. The appellant number 1 to. This. Well, appellant number.
entire land was subject matter of acquisition earlier.
No, what this is, appellant number 1 to 4 and respondent number 5 are brothers. They have independently purchased 2 acres, 6 quintals of land in different sale deeds. And sale deed is of 18, dates are also relevant, 18/4/1980. All of them have purchased independently under different sale deeds. And immediately after the purchase, mutation was effected on 12/8/1982. I produced the annexures also, that are not in dispute. Independent mutation was effected as required under section 128 and 129 of the Karnataka land, relying upon rule 88. Entire the mutation was effected. Thereafter, but on the same day, this gentleman, the fifth respondent, got the mutation entered in respect of all the properties. But on the ground that all of them have given the no objection. May I request your lordship to see the document. It is a clear case of we have not
Fraud and suppression.
Yes, it is fraud and also suppression of fact. Now, please come to the mutation straight away. I will take your lordship to the mutation entries. Please come to page. Mutation starts from page 134, annexure F. It is in Kannada, English also I have filed. And page 1, these are all 5 sale dates. But we are concerned, please come to page 139. English translation I have produced. But the fifth respondent is the eldest brother. Lordship got it for annexure here, page 134. Below your lordship may kindly, mutation was accepted on 12/8/1982. Annexure F, page end. But English also I have produced in English also it is same thing.
139.
Yes, page 134 Kannada, English at page 137 starts. In 4 brothers' name, the date your lordship will get at page 138. End. Mutation accepted on 12/8/1982. Lordship got it, Murad. Then Murad, please come to the fifth respondent's mutation. That your lordship will get at page 139. Mutation number 11 of 1982 in the first column. Page 139. This is Last may kindly say to BM Bettappa, the second son of late Malle Lingappa of Barandur village, by the first son of M. Singappa, etc. By the son of so and so. They have executed the document. Ultimately, mutation is accepted in respect of the land purchased by him on 12/8/1982. Similarly, my lord, for all others, it has been accepted. Then, my lord, what he has done is, on the same day, please come to page 154, annexure G. Yes, your lordship, kindly in Kannada, my lordship, this is very clear, but I will take your lordship to translation little later. Please take annexure G. In the middle, my lord, that the date is mentioned. Accepted, right hand side, accepted 12/8/82, same day. Please come to now in English translation. Page 157. Village Bidadi, 157. Yes. Under the application given by Sri Bettappa, the second son of late Malle Lingappa, son of Barandur village, Bidadi, Hobli, Ramanagaram Taluk, to the Tahsildar, Ramanagaram Statement, please see this. Under the application in presence of Revenue Inspector, Bidadi Hobli, on the basis of statement given by the following persons, Kata entry is made on the basis of the statement, Taluk number so and so, they have written it. Then the third son, etc. Gangaya, Samay, all these 4 appellants. Yeah, all these 4 persons have given their statement. Under that, Kata is made entry to the name of Bettappa, the second son of Malle Lingappa. In this regard, RTC number they have given. They accept. Please come to next page, madam. Accepted. How they have accepted? As per the permission. As per permission of Revenue Inspector, Bidadi Hubli, Ramanagaram Taluk, to B.M. Bettappa, son of Mallalingappa, being his brother, as per their statement dated 22/3/1982. But the mutation was effected on 12/8. How can it be 22/3/1982, much prior to the earlier mutation? And the Kata has made entry under the statement of Lingappa, etc., accepted in his name. But all five, the 10 acres of land has been entered in his name. But then this was continued, but this is in 1982. But this entry
Is a order of the Assistant Commissioner.
Assistant Commissioner order, Murad. That is page 160, Murad. Page 160, annexure H. But this order, I'm sorry, 1 minute, Murad. This order entry, without issuing notice to us, and then the records itself is not traceable in the department. That is what they have given an endorsement to us, saying that there is no such records.
Page 182.
Page 182, Murad, there is an endorsement. No, my Lordship wants to see the order passed by the Assistant Commissioner at page
182. 182.
Yes, 182, Murad. There is, I'm sorry, because there is one small, in the translation, there is little, page 183 onwards, please, this is in Kannada. English ಅಲ್ಲಿ ಸ್ವಲ್ಪ sentence ಎಲ್ಲ ಇನ್ನೂ ಮುಂದೆ ಆಗ್ಬಿಟ್ಟಿದೆ. Shall I read this, madam? Page 183. In the mid.
All entries are directed to be made by the Assistant Commissioners are pursuant to registered sale deeds.
Yes, madam.
Now what the Deputy Commissioner says?
Now, madam, these are all based on the sale. Now, Deputy Commissioner says the mutation was effected in the year 1982 and you kept quiet, you have slept over the matter. Therefore, the Assistant Commissioner order is correct. Set aside. Yes, sorry, Assistant Commissioner order is set aside.
Assistant Commissioner's order is in your
In my favor, I'm sorry. Yes, Assistant Commissioner order is wrong because 27 years delay is condoned without any justification. Therefore, I am setting aside and go to civil court. That's what he has written.
No, after 136(2).
Yes, ma'am.
How matter went in 136(3)?
That is, they have filed an appeal, ma'am, before the
Revision.
Yes. Better, Mr. Better, respond number 5 filed the appeal.
But
136.
We is except one judgment which again is doubted, that Justice NDV Bhatt, Mirde Saab and the Honorable Justice
Yes,
Babu, that Guru Raja Elias Guru Raja Kulkarni versus Land Tribunal, except that, which to some extent went contrary to counter to division bench judgment of Shri 85, 86 Supreme Court, 1058 Murugarajendra.
Yes.
That Murugarajendra appears to have been now revived because of the other judgments following that one. How revision is maintainable? Because section 136(2) uses the word final. That was interpreted in the light of Land Reforms Act in that Guru Raja Kulkarni. But so far as the the finality of the order under 136(2) bars the revisional jurisdiction appears to be the prevalent view.
But that is right. But my lord, what happened was in several judgments.
To him. You want to deny that one?
No.
Yes. Yes, Mr. Holla, how 136(3) is invocable?
My lord, my submission to your lordship says 27 years later, my lord, there has been, my lord, a partition in the family, admittedly.
No, question of law.
Yes.
Once kindly come to 136(2). Buddy.
Because this was not raised, I did not, my lord, look at that position of law.
Then
I will look it up and then, my lord, submit. Let me not waste your lordship's time.
Correct.
Because honestly, because that was not an issue raised anywhere. So I
Look into
I'll
two
in the light of
judgments.
what fell from your
One
lordship.
is ILR 86
I know.
Karnataka, page 1058.
I remember.
Another
this.
is the full bench judgment, I think ILR 97, something like that. Justice Babu and Devi Bhatt Sahib and Mirde Sahib. They have considered, to some extent, they went counter to what was decided by Justice Ramajoy's bench. It was Justice Ramajoy's and Justice Rajashekara Murthy. Ramakrishna.
It's a one judgment, but because I don't want to.
136.3. That was to some extent doubted by a full bench of this court. But however, somehow, one export judgment indicated final means even regional jurisdiction is barred. And in such a case, those who suffer order under 136.2, only option is for them to approach the civic court. This is number one. After how many, what was the delay of exercise of regional
27 years.
of revision?
No, by the assistant commissioner.
But the delay, continuation of delay is there.
I'll point out all that. This honorable court, my lord, has time and again held. After 20, your lordship's order is there, my lord. Of course, that is in the context of conversion, but then
Conversion it is.
conversion, but the same logic will apply. I'll point out.
Kindly read section 136. Kindly see the terminology of 136.2. It is not from the date of the order, from the date, that's how courts have held now. From that any person affected by so and so, so and so, within a period of 60 days from the date of communication of the order.
Correct.
This is interpreted.
Correct.
Unless it is communicated, the right of appeal is incoherent is the version of 3-4 judges of this court. And those entries, the assistant commissioner's order is structured on the basis of registered documents, sale dates.
Lord, what has happened is the family had, my lord, family was joined when it was purchased. 10 acres were purchased. It was purchased in the name of all the 5 of us.
97,
And then,
ILR 97. Perhaps that legal hurdle, if you answer, then we can go.
no,
to
no,
the
then
next.
my lord, let me not waste your lordship's time, my lord. Your lordship may grant me, my lord, some 2 days' time. I will examine that and then come back to your lordship's time. Let me not waste your lordship's time. Very well. Whether revision would be maintainable.
The deputy commissioner entered in the realm of civil deciding civil rights.
Right.
So there was a registered sale.
Registered sale dates, number one.
Number 2. There, my lord, I'll be able to satisfy your lordships. No difficulty about it. That, my lord, as far as the merits are concerned, no difficulty, but this hurdle, my lord, I'll have to cross. I will, my lord, let me examine it and come back to your lordship. Let me not waste your lordship's time.
You want 3 days then?
Anytime.
Whenever you want. Give the-
Next week, anytime, can you do your lordship's? my lord?
Fourth, maybe.
Please.
4th of April.
Please. 4th April.
Number 49, Mr. Krishnamurthy TR.
Then I'll appear for that.
Right in the
5312, sale deed is present, just 3 dates are relevant. 5312, sale deed is presented for registration. 53/2012, presented for registration. I am the vendor. Who presented it? The vendor, the purchaser presented it. Balance consideration was not paid. Therefore, she did not present herself for the complete formality, photograph and other things. She came outside. Lebanese sketch was not there. These were the 2 deficiencies. Now, Lord, thereafterwards, the purchaser, he forged my name and got a Lebanese sketch on, this Lebanese sketch is obtained on 9/11/31/10/12. That is about from 5/3/12, 7 months later. Date 31/10/12. Lebanese sketch is obtained. Now, Lord, without Lebanese sketch, it will not be registered. The signature on the Lebanese sketch was a fraudulent signature of the vendor.
Because my lord, both vendor must agree for the Lebanese sketch. So 7 months later, they concocted my signature, fabricated it and got a Lebanese sketch. Immediately, I filed a petition before the Tahsildar on 9/11/12. 9/11/12, before the survey authorities, saying that this is a bogus sketch prepared. Kindly withdraw it. I have never signed it. On after inquiry on 9/4/13, the Tahsildar, after inquiry and comparison of signatures, cancelled the sketch. On 8/11/13, based on the cancelled sketch, a bogus registration was carried out without in my absence.
Bogus registration.
Registration was done.
He worked in the registrar's office. What
Bogus,
is meant by that?
but bogus registration means
Illegal registration. You
illegal.
can word,
Sorry.
choose
Yes,
the correct
yes,
word.
yes. Illegal registration.
Illegal.
Illegal registration. Well, that is based on the fabricated document and based on his presentation. Now, my lord, after this, what I did, within 1 month, 19/12/13, I filed a suit, comprehensive suit.
19/12/13.
Yes. What happened in the suit? The suit went about or till about 10/1/20.
What was the decree?
The decree was the sale deed is held to be void, but court did not set aside the sale deed on the premise that the court was not aware that there was a registration of the sale deed. The court said, case is made out. The other side did not present himself for evidence. The proceedings were taken. Court drew adverse inference due to the absence.
Where is the?
Order
court
is at
decree?
page.
Just show it. Post
Yes,
court decree.
100. Order is at, suit order is at 100.
91.
91. Relevant portion is at page 102, para 16. Therefore, since the sale deed of the suit property is not at all registered as per law, but only presented for registration, and in the meantime, before registration, it was stopped by the Tahsildar, Doddaballapur, there is no question of cancellation of.
Please come to 103.
Yes. 103.
Last rock bottom.
Yes. So it's partly decreed with cost only in respect to relief of permanent injunction, and remaining part of the suit in respect of cancellation of sale
Dismissed.
deed of the suit property is dismissed. Against this, I preferred a RFA. I filed order 21 rule 27 application showing the registration before the first appellate court, which is pending. They filed a cross RFA. They said, then they withdrew the cross RFA with the liberty to move a miscellaneous. That miscellaneous is pending. Now, my lord, the central issue is in this whole case, so far as the instrument is concerned, it is seized before the civil court. But so far as the Lebanese sketch, which is a statutory act of the authorities, much before the suit, it was cancelled. What gave rise to the present list is interesting. What gave rise to the present list is 11/4/13, the Lebanese sketch was cancelled. 11/4/13.
Yeah.
November 13 suit was instituted by me, pleading all these facts.
Yes.
Though the Lebanese sketch is cancelled on 11/4/13, the suit is decided in 2020. 9 years later, in 2022, they file a writ to challenge the cancellation of Lebanese sketch without explaining delay.
Yes.
That cancellation in the form of a writ petition is entertained, and the cancellation is set aside without going into the question of delay. This one question, what is?
Assuming now,
Yes.
we'll assume against ourselves.
Yes.
That Lebanese sketch is bad in law.
Yes, because of the elements of fraud and.
How that assumes relevance for invalidating the registered sale deed?
Lord,
You have
registered,
lost the
yes,
suit.
Lord, precisely, Lord. Registered sale deed stands alone on separate issues. What I have pleaded for cancellation of registered sale deed is no consideration is passed.
Wherever subject matter sale is assessed to revenue, and the sale is not in respect full of the survey number, then to decide
Sketches.
should not fight with each other. Or they made a rule saying that you have to get the land. Sketch has to be.
Yes.
Sale deed has to be on the basis of the sketch. But some courts took the view, the 11 is. Some courts took the view, 11 sketch is not necessary. Yeah, no, mandatory. Others took the claim, it is mandatory. Somehow matter what happened to apex court in the 11E sketch matter?
I do not know, but I heard it was pending.
It is still pending. It's pending.
It is pending.
Question is, the courts of Mulla says in Transfer of Property Act, once the transaction is registered, there cannot be invalidation of the authority. No, some sketches or record of rights were not right, wrong, etc. Now it has a hand penalty. This is only a shadow boxing because by setting the 11 sketch, nothing is going to come out. The court has dismissed the suit so far. Validity of the sale deed concerned. So unless that the suit they get it. Now, because of divergent views of various judges of our High Court,
Yes.
there are 3 views of
Yes.
judges of our High Court.
Ultimately, it has to be
And
settled.
one
by-
judge is on the bench also.
Yeah.
Therefore, much you cannot say on the 11E skip because
Yes, Lord, all the
Mullah
time-
rights.
Yes, Lord,
Mullah
all-
rights in transfer of
Yes,
property.
Lord,
Act.
all that I'm saying is this, Lord. Just a very narrow compass, I'm urging my point. One is on the substantive document, that is the fraudulent document over which I have pleaded. The ground is that consideration is not passed and therefore it has to be set aside. That is pending in RFA. Court has declined. So far as 11E sketch is concerned, much prior to suit, it was set aside. So could the learned single judge have interfered? Only ground that this.
No, what emerges from 11E sketch, since document is already registered,
Yes.
11E sketch loses significance.
Yes.
Once document is
No, but
registered, please read that rule,
Yes.
130 something
Yes,
20.
Lord, there are two views, but one is that a 11E sketch is used for registration.
That's
Suppose
all.
it is one view.
Correct.
Suppose it is held mandatory tomorrow, then it becomes a document which is part of registration.
No.
Suppose it is held mandatory.
No.
Now, assuming, Lord, it is not held mandatory also. Lord, I would take the second point. Assuming it is not held mandatory, but without my knowledge, it is obtained fraudulently. I have an independent right to go and tell the revenue authorities because it is a court of inherent jurisdiction. Section 25 confers inherent power.
Against grant of revenue sketch or refusal to grant.
Yes.
What is the legal remedy in the act?
108, and I'm sorry,
108.
49, rule 49E.
49E.
Yes. Any dispute pertaining to such a sketch, 11E sketch, has to be raised before survey authorities.
It lies to
Survey authorities.
survey authority. You can raise that dispute before
Yes,
the
at
survey.
best,
authority.
what could be held against me, Lord, I'll place that also before your lordships to reduce the time. Earlier, these disputes were supposed to have given a notification. Earlier, these disputes were to be decided by Tahsildar. My representation for cancellation is 7/11/12/13. I'm sorry, 7/11/12. On 2012, this jurisdiction is changed to the survey additional director of land record. So by the time it came to be decided on 4/11/13, the jurisdiction had changed. That is at best what can be held against me. I'll show your lordships what in.
Jurisdiction once attached.
Yes, Lord.
By subsequent law, it is
Notification
not
it
taken away.
does. Yes, yes.
Because jurisdiction goes to the procedural law.
Yes.
Therefore,
Yes,
the courts have taken the view.
Yes.
Once the jurisdiction is attached.
And it is
list
instituted.
begins,
Yes, list begins.
subsequent change will not
Yeah, will
affect
not.
unless law otherwise says.
Yes, unless the repeal says.
That itself says something else.
Yes,
How,
please.
what is that shadow boxing going on? Assuming that the 11E sketch is held to be bad.
Yes.
What is its impact now? Because registration of the sale deed has happened now.
Yes, Lord, point is this. Assuming the registration has happened also. One is an independent fraudulent document obtained against me without my knowledge, I have a right and remedy. Because there is a legal injury as against me.
Is it your case that you have not sold the property?
I have not sold the property.
But that case is
It was-
negatived by the, in the suit.
No, what they say in the suit, the court was not aware that this property had been registered. The court was unaware of that. But kindly see the finding of the court. Court says since he did not present himself for the evidence, it is clear that my case is proved.
For voiding a sale deed, registration is not a sign.
Please, Lord, your lordships are right. On that point, I'm in appeal.
That's what.
On that point, I'm in appeal, Lord. But suppose, Lord, a statutory document is there. That statutory document is a precondition for another for registration, for a substantive contract between parties. And that statutory document is obtained by playing fraud. then I have a remedy before the authorities for getting it set aside. That will not, under two provisions it is saved. One is revenue courts have courts with inherent power. Therefore, if there is any mistake committed within those proceedings, those courts have the right to rectify it. This is one point. Second issue is.
It's only revenue court.
Revenue court. Up to Tahsildar, it is revenue court. Yes. So apart from that, rule 49E provides the remedy. Kindly see rule 49E, which is all comprehensive.
Read, please read.
Yes, rule.
One small question. I don't think that any court has decided it.
Yes.
What is the significance of 11E sketch? Once document is registered, I am asking you, what is the legal power?
I would place, sorry.
This question, what
Let's-
my learned friend has raised may not arise. The reason is this.
No, court has put a question to you now.
Now, my lord, the 11E sketch, my lord, what happens, the reason for obtaining 11E sketch under section 60, my lord, rule 46H of the Land Revenue Act, 11E sketch will be issued. That is because suppose a person intend to purchase a particular property, a portion of the particular property, then he has to approach the survey authorities under section 46. They will inspect the spot and bifurcate it, and then my lord, the bifurcation number will be given. That is the reason why 11E sketch is provided. In this particular case, she has taken the 25 lakhs rupees, then executed the sale deed, went to the sub-registrar office, presented it for registration. At the time of registration, she has instigated her son to file a suit and obtain an injunction. He brought to the sub-registrar, he came to the sub-registrar office and said, there is an injunction, don't register it. Then sub-registrar necessarily, when there is an injunction, he will not register it. Thereafter, I settled with her son. I paid money and settled it to withdraw the suit. Then she got the 11E sketch. We presented before the sub-registrar. Sub-registrar registered it. Then he has given it. Then she filed a suit immediately within a month. She filed a suit for cancellation of cancellation of the sale deed will be filed under section 31 of the specific fact, provided she is the party to the document. If she is not a party to the document, section 34 is applicable. Now, section 31 says they filed a suit for cancellation of the document that has been rejected by the trial court. Again, that she filed an appeal pending, but unfortunately, the appellant, they have not appeared before the trial court. They were ex parte. Then we also filed appeal. Then we realized that the ex parte order in Rule 13, withdraw it with liberty to file a miscellaneous. We filed a miscellaneous petition.
It's pending.
Yes, it is pending. No, 11E sketch was spent by itself. Lakshmi, kindly see the 11E sketch itself. Please see the 11E sketch at page 57. At page 57.
That money is paid by check.
Yes,
No,
no,
no.
she has admitted.
No, it is not paid by check. It is held to be, they state it is paid by cash.
Consideration is paid, my lord.
Madam, what 25 lakhs was not, she had a dispute with her brother. We paid 25 lakhs to her, she has admitted. 25 lakhs to him, and her son dispute has been settled. At the time of registration, we paid the amount. Now she files a suit against her brother, and she made her son to file a suit against her. And this is the modus operandi she is.
This is contrary to the findings of the civil court. The moot question here. Not 46
Last
H.
kindly come to page 58. Sorry, 59. Validity is up to.
What is the validity period?
Validity period up to 30/12/2012.
32. Before that, registration
Yes,
happened.
registration has happened. And now, what they are doing is taking advantage of this. They are producing before the civil court, saying that this 11E sketch itself is cancelled, therefore sale deed is invalid. Therefore, we have challenged it. Now, learned single judge has said, when there is already a suit pending before the court, you agitate your right. If you succeed, you will succeed. You take the property. That is what the view of the
Can I
learned
just
single judge.
kindly see 46H? That
And
was a
one
question
more
posed
thing,
by a
Lakshmi,
lodge.
kindly see the conduct of the party, very, very serious thing. They have submitted the Xerox copies to, they have produced the original document. Xerox copies of certain document, say for verification of the handwriting. And the expert says this differs based on the Xerox copies.
It is there evident. On a comparison, my lord, it is evident it is different.
Oh, Xerox copy.
No, not Xerox, on the original itself. We have produced before the expert. Even here, when on comparison, it is evident.
Page
Lord, kindly
169.
see 46H, can I see? Work specification, respective jurisdictional taluk survey office of any office of the revenue department notified by the government shall receive applications from the persons acquiring or alienating land in prescribed form and collect the measurement fee as notified by the government from time to time. Then, my lord, kindly see subclause 4. Licensed surveyor shall fix the boundaries of survey or ISA number before subdividing survey or ISA in the pursuance of all interested parties, duly recording the statements and draw measure in prescribed form. Such subdivided parcel of land should be well marked on the ground with boundaries. Then, my lord, the dispute portion. If there is any dispute regarding the title or extent and of any other nature, the application shall be referred to the survey department for disposal as per rules. Therefore, my lord, it has to go to the, kindly see the wording, my lord. If there is any dispute regarding the title or extent and of any other nature. Now, my lord, I come out of the, without registering, there is a dispute between me and them. How could they file an application, forged application, and how could they obtain a forged sketch? That issue, my
That
lord.
you can agitate in the
No,
appeal.
yes, my lord. Because of this rule providing a remedy, my lord, the remedy has to be separated. Now, my lord, assuming.
No, that has spent itself. It was for valid for a limited period.
Correct, my lord. But it was already cancelled on 9/4/30.
Huh?
This sketch was already cancelled on 9/4/30.
But
Kindly
before
see,
that,
my lord.
registration happened.
No, registration
that.
after that.
But
That is
how
the-
it makes any difference? It's only
Lord,
shadow
what would-
boxing.
issue becomes very serious, Lord. Reason is this, it assumes a deeper gravity. Reason is this, Lord. Assuming the sketches to be accompanied by the sale deed is cancelled on 9/4/13, registration is on November 13.
You mean to say if revenue sketch is cancelled, that will cast a shadow light on the
Lord,
validity
I'm
of
not,
the
no,
sale
Lord,
deed?
no, Lord, no, Lord. What I'm pointing out
You have
is,
suffered a decree.
Lord, so the decree is in my favor.
No, injunction
Decree.
is in your
Kindly
favor.
see, kindly see page 102, Lord, for a moment.
Decree, your judgment is irrelevant to us.
Yes.
What we have to see is always appeal is against the decree.
Yes.
Decree says your suit for invalidation of the conveyance is dismissed.
Correct, but an appeal is pending.
Appeal is pending.
Appeal
Therefore,
is-
why the shadow boxing?
Lord, no, Lord, what I would urge your lordships to consider is this, Lord. Assuming there is a cancelled sketch, can that cancelled sketch be used for registration is one thing, assuming it is used also. Then, can that cancelled sketch be again revived by a writ petition? This is the difficulty,
I
Lord.
have understood now.
Yes, how
This-
could it be revived
This
in a writ
English,
challenge 9 years later?
Justice Atkin called this dispute like shadow boxing. Therefore, I used it twice. How your rights are being affected?
Yes, Lord, another point.
You are already
Lord,
being
another point I would,
fighting the
yes,
title. to suit,
another point I would make. Lord. If under 46H6, I've invoked the remedy, under 46H6, remedy is granted to me. It is held that it is a bogus sketch.
You make use of that in appeal.
No, but that is, how could that later be set aside after the suit decree?
Everything is open now before the appeal. Your appeal is there. Fight that appeal. You have suffered a decree.
Yes, Lord, two things stare at us, Lord. Stare at this in the present context of present dispute. From the time suit was instituted till the time suit ended, the cancellation stared at their face. Statutory cancellation under 46H. If
we'll assume that there was no sketch at all, the courts have taken the view that is no ground for invalidation of the conveyance.
yes, Lord, I am treating that as a separate issue, Lord. But this statutory sketch has to be set aside and it cannot be revived by the court after a 9-year delay. And Lord, we have filed a criminal case. We have filed a criminal case under 420 that goes on to in a separate proceeding.
You fight appeal, you fight your criminal case. But this, so far as validity of this concern, let the judges say that there is nothing.
Lord, then one protection I would
So
say.
you only have presented the document.
No,
for
I'm not.
present- for
Lord, on
registration
5312 I presented, not for registration. Subsequently, I have not presented it for registration.
But it bears your signature and other
Yes.
things. Otherwise, it would have set aside, the court would have, the trial court would have set aside.
No,
the
no,
same.
what trial court holds is, I'll just read one sentence. Therefore, when defendant has remained as absent throughout the proceedings, not cross-examined PW 1 and 2, and not taken his own defense as per his written statement, the pleadings of the plaintiff can be presumed to be true and correct, and it can be held that the defendant, by practicing fraud on the plaintiff, got her signature over the ready-made sale deed of suit property on 5312 and given false promise for making balance payment of 62,50,000. But finally not paid that balance amount, and behind the back of the plaintiff, he tried to get the registered sale deed to suit
Your
property.
whole case is
Yes.
worse than what all you argued now. Read the judgment of the apex court now. If your whole case is consideration has not passed, except that one judgment, lone judgment of Honorable Justice Okasab, which again is now referred to the bench, to another bench has disagreed with that.
Yes.
Your right is for a suit for recovery of the sale price.
No,
Here, Mullah, take Mullah. Take Mullah. He's coming here to section 54.
Point is, money was not paid. I said that money was not paid.
Mullah has
Court
answered
held in my
this.
favor.
Mullah has answered this. A separate subparagraph is dedicated by Mullah.
Anyway, my lord, this is matter of subject matter of first appeal. That
You
issue
can
is
take up all contentions.
in the first appeal. Lord, can I seek one protection? That so far as the bogus nature or the illegal nature of this, whether my signature in 4011 E sketch is correct or not, could be addressed before the civil court, first appellate court. That much, if your lordship grants me the remedy, that is fine.
If separate machinery is worked out,
No, my lord, that machinery is not allowed to be completed. What has happened, my lord? That is precisely what I am urging before your lordships. That machinery I worked out and I won. Now, here, the trial court, the writ petition court said, without going into the merits of the signature, court said, address it in trial court. That's all I am urging, Lord.
Sorry, but this they have not produced before the learned single judge, right?
Now the sketch is prepared by vendor.
No, my lord, sketch is prepared by a licensed surveyor
Authority.
of the revenue department.
Based upon the description in the deed.
Based upon the description of the, no, not description of the deed, Lord.
Oh.
Based upon the actual survey marks, survey sketches and reports.
Naturally,
Naturally.
both
Yeah,
has to
of course,
match.
of course. Both have to tally. Both have to tally. Your lordships are right. Lord, what happened here was,
These are the issues to be gone into by pleading evidence.
then, my lord, that liberty may be granted because learned single judge, my lord. For all purposes, my lord, we do not find fault with learned single judge on merits. Learned single judge could not go into the bona fideness of both the signatures. He left it open and said, urge it before civil court.
All right.
If that position stands, my lord.
Kutwali, please be seated. The essential dispute between the parties relates to the sale deed, which has been on presentation, got registered, albeit with delay, arguably after the 11E sketch was rescinded by the authority. First, learned single judge somehow was not impressed by the submission of the petitioner side, the appellant side, and therefore declined indulgence in the matter.
It was there.
First, in the respondent side, full stop. The learned counsel for the appellant vehemently argues that the learned single judge could not have granted any reprieve to the respondent herein, in as much as the 11A sketch was obtained by presenting certain documents on which forged signatures of the appellants had figured. Full stop. Learned senior advocate appearing for the appellant, who was a respondent in the writ petition, vehemently argues that 11U sketch is a sine qua non for registration of the sale deed, and therefore that the registration could not have been done in the absence thereof. Full stop. He further submits that there is already a suit partly decreed in his favor so far as injunction is concerned, and the suit so far as title deed is concerned has been dismissed. And he adds that against the said decree, an appeal has been filed and pending before the court. Full stop. Be that as it may. Next one. Learned senior advocate appearing for the respondent herein, who happened to be the writ petitioner, opposes the petition, making submission in justification of the order of the learned single judge and the reasons on which it has been structured. Full stop. so contending, he says that the revenue sketch itself was valid for a particular period till 2012, and therefore the document in question having been already executed and registered, the entire dispute will be a shadow boxing. First up. Next up. Having heard the learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter in as much as the document, namely the sale deed in question, has been already duly registered, and therefore the validity of the revenue sketch now pales into insignificance. First up. More particularly, the suit filed by the appellants herein has been dismissed so far as validity of the sale deed is concerned, although there are certain observations which arguably may support that suit ought to have been decreed. First, be that as it may. First, both the sides agree that suit having been dismissed, an appeal still pends before the High Court. RFA. In RFA number.
And miscellaneous also pending before the same.
RFA number
572 22.
572 of 2022.
Filed by appellant.
Filed by the appellant herein against the denial of declaration as to the validity of the sale deed concerned, it will be open to both the sides to make submission in respect of validity or otherwise of the revenue sketch as well, based upon the material placed on record. First up. Next paragraph. Learned senior advocate Mr. G. Krishnamurthy brings to our notice that a miscellaneous has been filed in miscellaneous number.
First we filed RFA, then we withdraw it and filed.
Has been filed. Miscellaneous number.
Miscellaneous 29 of 2022, my lord.
29 of 2022. Before the court which had passed the decree in question, after withdrawing the RFA number so and so filed by so and so, and the said miscellaneous is stated to be still pending. First up, what should happen to the miscellaneous or to the RFA of the appellant now pending is a matter left to the court's consent. First up, in view of the above, the writ appeal being devoid of merits is dismissed. First up, however, our observations herein above made being confined to disposal of the appeal herein, shall not cast their light or shadow on the pending RFA or on the pending miscellaneous above referred before the jurisdictional courts. First up, all contentions of the parties are kept open for being urged.
Lord, the Lordship said submissions on Lebanese sketch. Could it be submissions and evidence on Lebanese sketch?
On the
submissions and evidence on Lebanese sketch. Then I'll have to produce evidence.
Declaration and the cancellation and that.
Cancellation of the sale deed.
The declaration of title anta ಹೇಳಿದ್ವಿ ನಾವು.
Cancellation of the sale deed.
Cancellation of sale deed. Please, Lord.
Custody to be handed over to the father, and we had sought for clarification from the Supreme Court. We have got the order. Yes, my lords, we have the order, my lords. That, yes. My lords, I'll just. My lords, I'll just hand over.
I'm required to file a second set in this, my lords. I will file this because earlier it was.
My lords,
in
may I
one
just
single
pass it?
What happened to matter at the hands of the apex court?
My lords, at the apex court, the respondent mother had filed a transfer petition. Transfer petition that is still pending, my lords. And my lords, may I
said that
just.
the court can deal with the contempt and the writ
Yes,
petition
may I just
on
read
its
out,
own
my lords?
merits.
My lords, what is very important, in fact, the court holds, obviously at the time of passing of the order dated 16/2, staying further proceedings in the custody petition GNWC so-and-so pending before the family court. The fact that in relation to the order dated 6/2, which is that interim custody order, my lords, passed in custody petition number so-and-so, a writ petition being WP and contempt are pending before the High Court of Karnataka was not taken into consideration because this was never informed to the Honorable Apex Court. The fact is that the said order is thus under consideration of the High Court of Karnataka and aforesaid matters are not being taken up following the interim orders passed. In the said circumstances, we make it clear that the pendency of this transfer petition shall not cause any legal trammel for the High Court. Now, my lords, therefore, in light of this clarification, my lords had in fact asked us to get the contempt. My lords, it's extremely urgent. Could my lords take it up tomorrow, at least at the top of the list, my lords? Tomorrow, grateful. My lords.
Lords, in the meanwhile.
Laches permission.
In the main.
In the beginning?
In the beginning, grateful, my lords.
Just with your Lordship's permission, serial number 50, interim order may be extended.
Lords, in the contempt, the second set, shall I?
Serial number 50,
The registry, my lords,
interim order may
the
be
second
extended.
set.
Will be extended.
Please.
Wherever it is there, extended.
Sir, I'm affected person. I'm 14%, sir. They have taken stay. Who BBMP directed.
ಸ್ವಲ್ಪ ಹಿಂದ್ಗಡೆ ಹೋಗಿ ಕೋರ್ಟಿಗೆ ಎಲ್ಲಿಗೆ ಬರಬಾರ್ದು ನಮ್ ಜಾಗ ಆ ಕಡೆ ಇರ್ಬೇಕು. ಎಸ್
Lords, in that, sorry, my lords, in that matter, may I seek for Wednesday instead of tomorrow because senior counsel is engaged and he's coming on Wednesday.
There is the council.
No, she is here.
Tell Generals.
She's
General
there.
it on Tuesday, Wednesday we will have
Wednesday,
that
if it
matter.
is okay.
One day, nothing will happen. Wednesday.
Grateful, my lords, grateful.
50, sir, 50. 71 is the.
Learned Advocate Ms. Jaina Kothari produces the order of the Supreme Court. However, Learned Advocate Ms. So-and-so requests that the matter may be kept on Wednesday, that is 7th of, 27th of, 10 to 10.
Lord, with the Lordship's kindly, my lord. Serial number 72, my lord.
Number 50, sir.
Serial number 72, there is a threat of disposition. The Lordship may fix, serial number 72, there is a threat of disposition. The Lordship may kindly take the matter tomorrow, day after tomorrow.
Distributed, all matters will be distributed.
Lord, 51, my lord. If I
What do
may
you want?
mention.
What do you want? It will be given.
Serial number.
Within 10 to 12.
Lord's kindly, my lord, serial 59 was posted today for payment, my lord. A contempt matter where, my lord, the landlord had to deposit the rents.
Yes.
It was directed to be placed on top of the list, my lord, it has. So therefore, I think, my lord, they had also got the payment.
They have received a DD for the entire amount.
You have brought the DD now,
Yes, we have.
deposited with the registry.
For 2 weeks time may be given, we'll proceed with the proper application and deposit in the.
What 2 weeks? You have brought the DD now, you have to along with the memo, it has to be tendered
That we deposit in the trial court, please.
in the trial court.
Please, ma'am. So we'll make necessary application, advance the
Next,
matter. and
next
get-
week you can do that.
Next Monday?
Yes.
Next Monday.
Very well, very well. 51, my lord, great.
One
Great.
Milord, it is a public road blocked, Milord, between two landlocked villages, Milord. They are even ambulance also not moving, Milord. Kindly post it tomorrow, Milord.
After 2 weeks.
Milord, even ambulance also not moving, Milord. But they are suffering a lot, Milord.
All right, we have said that, we have said, you have said, we have said, yes.
51, my lord, sometime next week, my lord, it's a short matter, but where a direction is issued to the conciliation officer, my lord, under the ID Act to undertake proceedings, my lord.
50.
Section 51, my lord, 51. Will be rendered infructuous, my lord.
Next Monday.
Grateful.
Serial number 67, my lord. 67, my lord, it is identical matter has been disposed of, my lord. This matter also will next week, my lord, to be taken up next week.
Dispose of against you in your favor.
No, it's I have media, my lord.
Favor or against?
Granted some time, my lord, and to pay the EL encashment.
Serial number 50,
Next
sir.
week, after.
Sir,
I already served the copy on other side.
serial number 50. 50, sir.
Date
serial
will
number
be
50.
given, date will be given, distributing the matters depending on the size of the board. Every day. Unless there is an extreme emergency, we are granting early.
Yes, sir. The direction is given, sir, to BPMP.
So we'll take up after 10 days.